got all the things that you need to just before we get started.
We sent the team's invite to the landscape architect, so he might jump on as well. But also forwarded it to Catherine, who's my partner, who is maybe just going to sit in. Is that okay?
Yeah, that's totally fine. Yeah.
So you guys will kick this off. Okay, welcome everybody. Sure, I've got all this right. We've got the hearing today for resource consent 260040, and in relation to a subdivision consent for a 2-lot subdivision and land use consent for a building platform and residential dwelling in a rural resource area. Just wanted to, first of all, before we start, just a couple of things. You can see that the hearing is being recorded, so just letting everybody know that's the case. And I'll do some introductions first, just before we kick off everything. So Tracy Patterson, councillor and also commissioner, and the chair for today.
Chair Brown, councillor and commissioner. Kirsten Roy, panel advisor. DC Duck, hearings administrator.
Duncan, I'm the planning consultant reporting on this application, and I'm the author of the 42A report.
Paulin, architect and son of the applicant, Kevin. Hi, Kevin.
I'm Bridget Irving, counsel for the applicant.
Tanya Copeland, planning consultant.
Louise Sullivan, law clerk at Galloway Cook Allen.
Thank you. And have we got anyone online at the moment, Jessie?
Not just yet.
Okay,
Yeah.
right. So if you could just let us know when someone comes on, just in case I'm not concentrating.
Yeah.
Now, we did just note that at a previous hearing, the sound, it runs out of this box up here. So can we just make sure that we've got a big voices, so that just in case for all of the people watching online. Okay, so in one other small matter, just in case Commissioner Brown needs to stand up, she has got a back injury at the moment, so she may need to move around just in case.
But yeah, if it's not you, it's me. I'm fine.
Yeah. So this is a properly convened meeting of the hearings panel called, as we've already discussed, for subdivision consent, land use consent. I'll ask Jessie to report on the proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the planning consultant has been circulated to address for service and all submitters, and the submissions received have been identified in this report.
Thank you. So as per normal procedure, we will be, the panel will be asking questions. Council officers or its consultants will direct any questions or points of clarification through the chair, and that the chair will be deemed to be the person asking the questions. Obviously, after that, we'll have the applicants' representatives who are here today and possibly online to make submissions and present. And then after that, Section 42, Kim will be doing her part. And then after that, we will have the applicant's right of reply, how you wish to do that today. Matter of course. But before proceeding, I'd like to just deal with a procedural matter. And that is, actually, first of all, I might just say, I will move a motion that the 42A report be accepted. Thank you. And then the procedural matter that I'd like to address is, and this is something that I'd like both parties to deal with, and that is, which I'd like clarified, is the matter that what's the status of the affected party's approval, and that's essentially in relation to, and that's page 7 of the 95 report. That other than the landowner at 1031 didn't sign the plans. So if we could just deal with that, please. Yeah, other than that, that's the only procedural matter that I'd like to have dealt with at some point today, please. Anything else? No. See nothing from you procedurally that you'd like to? Okay. Right. And that over, you go through whoever's going to
Thank
be.
you. Yeah, so I start, and I just thought I'd just briefly take you through the legal submissions that I have filed. I won't do that extensively because I'm sure that you will. But I suppose where I understand things are at is that there is, in essence, consensus about effects, and that the adverse effects of the proposal are minor or no more than minor. And so where the issue of contention arises is perhaps around that question of rural fragmentation and precedent and plan integrity. And so that is, I suppose, where I thought I would just focus my initial comments. Since the Section 42A report has been provided, we've now provided additional evidence in relation to the site and its productive utility, and that's been provided by Kevin Paulin. Now, obviously, Kevin, by virtue of being the applicant, is not an independent expert. However, what's clear from his evidence is his long-standing experience and knowledge of the site, and he obviously has extensive experience as an orchardist and horticulturalist. So it's my submission to you that that information is information that you can give weight to, and should, I think, assist your decision making in relation to those questions around the rural productivity of this particular site and whether the subdivision is going to compromise that in any meaningful way. And his evidence is, in essence, that the sort of topography and location of this particular site makes that lower terrace where Robert's looking to build the property of limited, if no utility from an orcharding point of view due to its climatic conditions. And so the subdivision isn't going to compromise that, the ability for the site to be used for those productive purposes. And if anything, having Robert living there and able to develop the site for those other types of uses where there might be some potential nuts and vegetables and things like that, would serve the policy directions of the district plan. Turning to the matters of plan integrity and precedent, I think that the threshold for creating a plan integrity issue is quite high. And the case law that I refer to talks about there being, irreconcilable clashes with the policy direction in the plan. And in my view, an application where the effects conclusion is that effects are minor or no more than minor, it is very, very difficult to see how a proposal with that conclusion can create an irreconcilable clash with the provisions of the plan. And particularly in relation to this district plan, where the policy framework is a real effects-based framework. So it's my submission to you in the face of that conclusion around effects that precedent and plan integrity issue really doesn't arise. And the application safely gets through both Section 104D gateways, and in my view, on that basis, the decision should be that consent be granted. I think are really the key issues I wanted to highlight. So I'm happy to take any questions that you might have, and if not, I'll be calling Robert to speak to his evidence.
Yeah, just bear with me. I'm just make sure that I've. Now, I note that you refer to Make sure I've got the right page here. With regards to case law, and you talk about the Gould case and Beecham. Where are we? Yeah. And are they the most up-to-date cases for plan integrity?
No, they won't be the most recent cases from memory, but they were the ones that we felt were most relevant.
And would there be any reason to have those cases, would they be distinguishable at points of law in relation to this application?
Need to double check facts to just make sure I'm not leading you down the garden path, but we did consider a range of cases on precedent and plan integrity and referred to these ones because we felt they were the most relevant to this particular scenario. But I can go back and just double check the facts of each of them and confirm that for you if that was helpful. I think Gould might have involved discretionary application, but I just need to refresh my memory on that.
Q. It's my only question that I had in relation to that. Thank you.
Right. Robert, would you like to speak to your evidence?
Yeah, sure. This is just a statement outlining what our reports said. So, kia ora, my name is Robert Paulin. I'm an architect based in Clyde. So I'm the applicant, Kevin. If consent is granted, I intend to live on the property, Block 2, with my family. I prepared the concept and dwelling design some time ago. I note that the Section 42A report recommends consent for the dwelling, which we are pleased with. However, the subdivision is necessary to enable the dwelling to be constructed, as a separate freehold title is required to secure a bank loan for me and my partner. The proposal will provide a permanent family home while retaining the rural and productive character of the site. The dwelling has been positioned to minimise the loss of existing orchard trees, with the balance of the property remaining a rural lifestyle block. The dwelling has also been designed to sit low within the landscape, with its scale, roof forms and materials carefully considered to complement the rural setting. In summary, the subdivision provides the practical means to establish our family home while retaining our rural character, productive use of the balance of the property.
Thank you. Questions?
With those plans were signed off. There's been no changes to the plan, but you said some time ago.
No
Still-
changes. No, it's just
Still.
we've just
So
it's been a project for a long
signed
time.
off, but affected parties are still.
Yes,
Good.
yes, terrific.
So I guess my questions, I think some of them, in relation to where this comes, I'll direct it here, but it may get Tanya might answer this one as well. In relation to the building footprint, why would you need such a big footprint, and why would you need such a footprint at all?
You're referring to the building footprint or the building platform?
The building platform, sorry.
Platform. Building platform is set 25 metres off each boundary as per the requirements of the district plan. The formation of it is slightly larger than the building, which is typical of any of these subdivisions. That sort of allows for any, if there was to be any, not that there's any considered to be at this time, but any minor tweaks to shift it within that building platform that might be in way of Orientation towards sun, basically, I'd say.
Yeah.
So, yeah, but it's not the intention of the application.
Okay, and obviously, given the underlying zoning of the land, there is specific things that are allowed to happen as a matter of right. It's under my understanding, is there anything additional that you were anticipating building within that building platform? Sorry, just the dwelling.
The documented drawings is what's intended to be built on site.
I do have a question, and it's probably just because so I can understand it correctly, whether it's yourself or Mr. Paulin here, in relation to the 800 and above growing degree days, and how that, what does that actually, just so I can understand that from a practical point of view?
Well, yes, I'm no expert on only wants to argue, but a growing degree days are worked out. I mean, it's a scientific worked out on the number of, correct me if I'm wrong, but it's something like the number of hours above a certain temperature on average, which doesn't take into consideration diurnal variations. So, I mean, obviously Central Otago, this basin here, we have very high growing degree days because of our very warm summers. But it doesn't really take into account. So it's a matter of temperature above a certain degree, not about. We have another unit we use for that, which is called chill hours, which is the number of degrees below a certain temperature, I think 7 degrees, and obviously we have a lot of those as well. So it doesn't take into account those diurnal fluctuations that we get, and that particular site, as stated in our evidence. If anyone knows about cold air drainage and whatnot, it's probably some of the coldest land in Insklu. And the growing degree days does not really have any relevance to that particular. That explains it. I'm no scientist, but.
And I should note that we haven't done just at this stage, we've only seen the pictures that you've provided as far as the application. So I should have clarified that we to do a site visit post the hearing, but just trying to understand from what we've seen. It needs to be sorted out later on, but so that we can understand exactly what goes on with the property. So I'm assuming applied the fact that you may be looking at a alternative use potentially for that site. That is a possibility. Is that anything that
A productive use? Yes.
it's a productive use?
Yeah, most definitely. It's going to be something that we work out once we live with the land, work out what actually grows. So there is irrigation already down there, which, as you'll note from the report, it's been left, but the orchard's been pulled back some time ago because those trees just weren't doing well. So we'll be looking to use it for something. We don't know yet.
Thank you.
Speak to his
Okay, I'll
evidence.
just a couple of notes, but yeah, my name's Kevin Paulin. I'm the applicant, and I've lived on this property with my wife, Margaret or Meg, for over a decade. We've made in support of our son Robert and his partner Kathleen to establish their family home nearby. My evidence focused on the productivity capacity of the site. I have over 40 years experience in horticulture and represent the third generation of our family involved in fruit growing in Central Otago. The site has been part of our family orchard history for more than 50 years. apricots, apples and nectarines have all been trialled on the lower terrace without any lasting success. The lower terrace, as we discussed before, has very, very light, sandy, wind-blown soils, has very poor fertility and poor cold air drainage, making it significantly more prone to frost. In my experience, these conditions make it unsuitable for commercial fruit production. In saying that, as was mentioned before, there is a possibility that other crops could potentially be grown there with the use of the irrigation. The proposed lot 2 is located on the less productive part of our site. The long-term history of the site provides me, in my view, a clearest indication of its actual productive capacity. If this land was suitable for commercial orchard production, we would have developed it accordingly many years ago. And just a note, the only thing I'd like to say is that, my wife, Egg, who would have liked to be here today, but we'd just like to say that we've, fully in support of this application and, and very excited to have our children living close by. So thank you.
Thank you. Just a question in relation, obviously you've got a long history with this piece of land. In relation to the elevation of levels of copper, is there anything that you'd speak to that in relation to, and I accept that they've been recognised as less than minor, but is that something that, can you explain that in relation to the horticultural activity that would have gone on in the past?
Yeah, the reason for most horticultural land in industry will have some copper is because we, over years, have used copper sulfate sprays, which is a very common spray used for protection of bacteria and fungus on fruit trees. The fact that it's very low on that side is the fact that it hasn't been an orchard very long. I mean, some orchard land, may be an orchard for over 100 years. I mean, it's especially that bottom terrace. I mean, as stated, we've attempted to grow trees there over the last 40 years, but it's probably only had 10 years of copper sprays. Look, don't quote me, around about that anyway. So copper sulfate, very common in all horticultural, especially stone fruit. Copper sulfate's not used in pit fruit. But any stone fruit operations over the last few years will have some copper, and it's quite easily mitigated because it tends to just sit on the surface, and that's why it shows up in those samples. With any cultivation or thing and whatnot, those concentrations drop away very rapidly, and even at the levels that they are at of no health concern to anybody. But yeah.
So that, just confirming that is obviously just quite a normal application of.
You find that in most historical, yeah. Fungus and leaf curl and bacteria and it's a cover spray they put on. Yeah, we put on the order. You put it on a leaf. You put them on over the year. You put them on as the leaves come off. You'll notice on nectarine and peach trees, if you don't spray it with copper sulfate, you'll have curly. I mean, that's why you don't grow nectarines and peaches in backyards, because if they don't get copper sulfate sprays, it'll just be all curly leaf. And also kills a lot of can kill some mites and things like that too.
So in your opinion, obviously, in your experience, which is extensive here, in relation to, in your own words, why can you clarify what your real opinion is as to why that piece of land has not been as productive as you would have liked?
The main reason would be is its proneness for frost. Most stone fruit, you only have to look around and see where the orchards are, stone fruit orchards are grown in Central Otago. Most of them tend to be on the slopes and slightly at higher altitude because of that frost drainage. That would be the number one, and the second one is the soil conditions. It is very light, sandy, wind blown. Look, we did some digger. There's about this much top, 10 centimeters of sand on top of gravel. So it's all very, it's through alluvial floodplain. So yeah, they're the two main reasons. And to be honest, with the cost of developing orchards in this day and age, you have to be incredibly careful of your site selection, because the development costs involved in an orchard, you need to be selecting the best land possible. And as I say, I mean that a lot of those Ernst flats are not suitable for stone fruit production.
So having your time again, you still wouldn't put that if you were to go and you wouldn't, there's nothing that you could do to essentially.
There's nothing we would do. I mean, it would be a waste of our resources to plant. I mean, the cost of it, you know, the trees alone, and then the 5 years to get them into production for them to, I probably didn't explain why the soil condition and the frost affects the tree health. That's the main issue. The trees go under stress more because of the frost. Well, the sandy soil causes stress because of the water, retention inability in the soil, and then you've got the frost, which gets into it causes damage, which allows bacteria to get in. So it's more about those conditions causing disease to get into your trees, and without a healthy tree, you can't grow a productive crop.
Thank you. No, that's very clear. Thank you very much.
I'll also do just a bit of a summary at my evidence is read. So just some key points that there appears to be quite a consensus between the applicant and Ms Banks that the effects are not more than minor on landscape, rural amenity, open space, transport, servicing, and reverse sensitivity. There's quite a critical consented baseline in play here with the existing land use consent for the second residential activity. The applicants volunteered to surrender this land use consent to ensure that there's no net increase in residential activities in the receiving environment, and it further relocates this second activity to a less prominent site on the property. Future development should carry limited weight. Any future minor units, accessory buildings, worker accommodation or traveller accommodation activities are not before the panel. Any of these which are permitted activities have been accepted by the plan as being acceptable, subject to standards, and any other activities requiring consents would be assessed later on their own merits, subject to further applications. The site and the proposal do have some distinguishing features. It's already an undersized rural allotment at 4.43 hectares, and it's located directly adjacent to the rural residential area, which is the Picnic Creek subdivision. The site has a distinct terrace landform, which forms a physical fragmentation. There's an existing orchard, which is proposed to be retained. The consented baseline, which I talked about before, visually recessive building location and landscape mitigation proposed. Rural productivity effects are argued to be less than minor. The lower terrace, as we've heard, has some site-specific microclimate constraints. The proposal retains the soil in situ and still available for rural productive use. The orchard is to be largely retained, and both lots retain irrigation access. And just further to that, just picking up on the comment before about that 800 growing days. So that's included in the district plan in section 2, where there's a very broad brush mapping of these 800 growing days. The scale is actually 1 to 500,000. So, you know, it seems to intimate in the district plan that this is done mostly on soil types. Probably, I would imagine, given the scale, doesn't really take into account microclimates and specific soil properties. And so that's where that has come from. It doesn't actually translate the 800 growing days into any specific provisions or objectives and policies in the plan. The The proposal supports community and business wellbeing, which we've talked about. It provides intergenerational living, separate finance security for the new dwelling, and succession and resilience for the Paulin family. These are woven through the objectives and policies about economic wellbeing of people and communities. And a assessment of the objectives and policies supports the application. The adverse effects are found to be no more than minor and do not conflict with any objectives and policies. Happy to take questions.
Okay. Do you want me to take off? I just have a couple of questions. The max, and maybe that could go either way, the maximum height of the building, it was noted at 5.2, but then further on it is 5.5. Which one is the correct number?
Well, the district plan provision is 7.5, which both would be well under that. There's no consent to breach that. And I don't believe there's a condition which restricts it. Check these. All residential buildings would be no higher than 5.5. So 5.5.
The drawings show, I think, 5.2, and then I think we'd probably allowed for a 5.5 because until we get engineering report on where the pool level can sit in relation. So I'd say as documented at 5.2, and then we'll expect no roof higher than 5.5.
It's going to be dependent on.
The intention of the application is to consent that specific house design. So either there needs to be a little bit of contingency in that. Because generally it's measured from existing ground level. That could be something we could have a look at just to ensure that it would still comply with that condition based on this specific house design which has been applied for.
Okay. So I'll just go through my questions as I've got them written down here just to make sure I've got them. So the section 42 writer identifies that there is no protection on the landscape mitigation plan to retain existing orchard plantings. However, we've just heard that that is the intended. You just confirm exactly what your client's position is in relation to those.
Yeah, so they intend to retain the orchard. Probably not in perpetuity, because orchard trees do have a life. We want to talk to Kevin whether you.
Well, yeah, I mean, those trees are only 6-7 years old. So, I mean, and they're peach trees, flat oak peaches. Normally a peach tree you'd expect to have a life of 20 to 25 years. At that point, I mean, depending on varietal changes or whatever, there's no reason why we wouldn't change them over. But yeah, we'd expect them to be there for another minimum of another 15 years anyway.
And also there is a discussion about from Ms. Banks that there is going to be that the rural boundary is going to be blurred. If we were of a mind to consent, do you have any comment in relation to that comment from Ms. Banks?
Yeah, the site directly abuts the rural residential zone. They're both rural zones. They're both subject to the same objectives and policies. They have slightly different provisions when it comes to consent triggers for minimum and average lot sizes, but otherwise the activities on each are in general roughly the same. They both anticipate residential activities and small scale productive use. Picnic Creek subdivision has been developed to a level which is a lot more intense than the district plan provisions anticipate. And the site we've got here is already an undersized site, so it's already less than the average that's provided for by the plan. And the proposal seeks to maintain that 2 hectare minimum, which on an already undersized site seeks to kind of retain that separation distances and the density of development and maintain that open character. So I suppose our position is that the density of development is consistent with that. It's not introducing any activities which aren't anticipated or which could conflict with the Picnic Creek subdivision. And effectively there's kind of a mirror between this 2 hectare minimum in the rural area and the 2 hectare average in the rural residential. So I think the boundary still is there. It still retains. This is still a rural site. But at the end of the day, we're considering the effects of such. And, you know, I think there's a consensus that the effects of this proposal are acceptable in that regard.
Okay. And, reverse sensitivity. Obviously this is as you just acknowledged, it's a rural, predominantly horticultural area. Is it enough that associated effects should be anticipated in relation to that reverse sensitivity?
So reverse sensitivity goes 2 ways, obviously. And as I just talked about, the rural residential area also anticipates productive activities, as does on this site. The neighbouring properties don't have intensive productive activities occurring otherwise. And kind of given this receiving environment, I think there is consensus that these rural sensitivity effects, the occupiers are well understand the environment, and they're just considered to be less than minor.
And can you just confirm for me that the new wastewater disposal field that's been applicable for the new lot, that's going to be each of their disposal fields will be contained within each individual proposed new lot?
Yes. Yeah.
Just a note, the Earnscleugh irrigation letter, not the domestic one, the irrigation letter isn't dated. So do you have a date that you received that? While you're looking at that, it's in relation,
That's the irrigation one.
Yeah.
yeah, so it's just the letter that.
From Mike Tubbs.
Probably from Mike Tubbs.
Yeah.
Folks.
Yeah.
Thank you.
Here.
Sent to me or sent to you.
It's to you, I think.
Now you're asking for my technology.
Just when you find it.
Here it is. It's the 5th of January 2026.
If you wouldn't mind, could you just forward that email so that we can put that on file to Jessie, please, just so that we've got that. Just another one, just something, and whether this will, sure where this will come up. Just at that outset, I did mention about the status of the affected parties' approval. Whether you deal with that.
Yeah, do you want to just so I can answer you probably, just confirm the address of the approval you're concerned about?
So no, I'm not concerned about that. So what I've got here, I just want to, so the, this is page 53, which is page 7 of the 95 report. I just, where are we? I'm just making sure this is 53 of our documentation. And it's page 7 of the 95. And obviously I will be asking Ms. Banks the same question. That there shows the affected parties, but they only the persons in 1031 Earnscleugh Road actually signed the correct documentation. But then it was notified. So now I'm just questioning whether that what the status of that affected parties' approval.
Probably answer that. So I think we early stage of the resource consent, we got the affected parties approval from the surrounding neighbours, or who we are thought to be the affected parties, which were the ones touching the boundary. 1031 returned the signed document and the plans, but all the other ones just did the form. And Ms. Banks informed us, but it was after we'd made the application. So then we went and got the following the remaining neighbours to re-sign with the plans. So I think we were asked, we were told we weren't needed to get the 1031 because they'd already given their affected parties. Is that correct, Kim?
So we'll get Ms. Banks to put that out at her time. Yeah. Okay. Sarah. Okay. Nothing for you? Okay. It was everything from me. Thank you. Anything else? No one else is online that we need to know about? Yeah.
I do wonder if just a couple of questions you asked about the conditions and the height of the building. I think that the way that the land use consent conditions are currently proposed, you've got condition 9, which talks about the plans being the application and activity being undertaken generally in accordance with the approved plans, except we modified by the following conditions. And then you've got the condition at 14, which says that the residential buildings are to be no higher than 5.5. So in my view, those two things actually work together quite happily. You've got a design for the house, which says, and then we've got that additional control in place that kind of puts for lack of a better word, a lid on what can be built. So I don't think that there's an inconsistency there that you need to be worried about. I think that they work together quite happily, and it's not an unusual way of managing the sort of detailed design kind of variations that can occur when you need to complete your engineering design later. In relation to the retention of the orchard trees, I think where we landed was that it would be appropriate to add a condition that required the retention of those trees, but to allow for the renewal of the orchard over time, we thought it appropriate that the trees be retained, and if not replaced within how long, say 3 years or something like that, then you put in place some additional boundary planting to provide that visual screening from the road if the orchard trees were to go back in. In addition to the plans, I think would secure the outcome that's been assessed by the landscape architect.
And so have you got any proposed wording in relation to that?
The drafts, yeah.
Okay. And obviously Ms. Banks will probably pick up on that point. And we can go from there. I'll just make a note. Okay. Thank you. Right, Ms. Banks.
So the conclusion of my was the approval of the land use component for the central dwelling in the building form. And being on the basis of the expert landscape has been provided. And the conclusions of that being that the effects will be it's a minor. And also on the basis of the proposal to surrender the existing land use consent for the second residential unit. On the subdivision consent, I have at this stage recommended that that be declined, and that was on the basis of uncertainty over the effects on productivity, resource, and concern over precedent with the land being on the boundary of that rural residential zone. I've considered the evidence that's been put forward by the applicant, and on the matter of productivity, while we don't have any specific investigations or soil analysis to I guess support what I'm saying, I take that your experience and knowledge of the land is relevant, and that should be considered. It's relevant expert evidence. You've indicated that that land is not suitable for productive, it's less about suitability for productive use. I also consider that the fact that you own an orchard, you've been running that for a number of years, and the fact that that land hasn't been incorporated into that for some time, it's can assume that to what you're saying, that it hasn't been considered that that land has significant value for that purpose. So on that point, I consider that the applicants indicated that the effects that I had indicated might be minor or more than minor, are not so. I would reconsider that position of my 42 report. As to the precedent matter, I consider that that is, I suppose, a relevant concern also on plan and on paper, as compared to reality and physically on the ground, and recognising the character of the area and the adjacent land uses, and the fact that proposal will integrate well with the adjacent land use of the Picnic Creek subdivision and the landscaped character of that adjacent land use, as well as the lot density and development density, and the fact that it complies with the minimum lot size of the rural zone, but not the average. Being demonstrated through my report, but also the applicant's analysis of the objectives and policies, that the proposal is not fully contrary to those provisions, and it does. I agree with some of the points that have been made about the fact that the proposal does implement other objectives of the zone in terms of supporting rural development and land management through enabling that accession of land use through the family. So that the precedent matter may be of more concern where the effects of the precedent are considered to be significant. And in this case, I've concluded that the effects on the environment will be no more than minor. So agree somewhat that the precedent concern may be over elevated as has been outlined in the legal submissions. In terms of, do disagree with Ms. Copeland somewhat in terms of the suggestion that the future effects are not relevant. And my understanding of the proposal was that building platform, the key component of it, and I had recommended a condition that residential buildings be contained within the platform. And then there's the potential effects also of the resulting effects of the subdivision, creating the potential for future permitted activities, including additional mining units, which are now enabled with these detached mining units. So while I agree it would be considered on their merits, it's relevant to future resource consent applications. However, I think it is still relevant to consider permitted baseline that is expanded by the subdivision. And the application does offer to surrender that existing residential activity to enable the proposal, but then NE still enables potentially 2 more additional mining units on the site, and with the removal of my recommended condition that be contained in the platform, those mining units could be located anywhere on the site. And I don't think we've got the landscape architect.
You can join them on if you want to.
Yeah, I'm not sure if that's considered or whether the conclusions that were reached in the landscape assessment were on the basis that, on the assumption that the buildings would be contained within that platform. Buildings as well, and usually, additional domestication effects that can arise from different mining units being dispersed throughout both lots. That could be addressed through suitable conditions to avoid those effects. In regards to the landscape plan, again, the protection of the orchard centre of the site was not identified on the landscape plan as being for protection, although I understand it's indicated you're not planning to remove that at any point. That understand that those orchard trees may need to be removed and they may not be desirable over time, but whether and I had recommended a condition that an amended landscape plan be provided that demonstrates the replacement planting of those trees. Didn't necessarily need to be other orchard species, but with suitable species to provide that screening effect and ensure that that is integrated with the character of the adjacent picnic grove subdivision. It's been provided to the landscape conclusions that have been reached. That's what I want to say in response to the applicant's evidence. The written query of the written approvals. So Paulin said the approvals were provided, only one had signed plans at the time. Then we went back and amended approvals. And I think some were received, but not all. And in any case, the application was that the written approvals are relevant to the Section 95 determination. And the application was notified in any case, all of those. Notice, except the one that had provided signed plans. Following that, all the adjacent landowners have provided submissions in support of the application. The outset, although some without plans, and then submissions in support. Included plans, I believe.
Yes. Some didn't get back to us. So
So. Sarah, any questions? Thanks.
Yes, hang on, how do I phrase it? Obvious statement, no. Adverse effects from future development. Future development can't be treated as an adverse effect to subdivision. To my understanding there, because it's permitted activity to go into the residential money unit specifically for each. But from what I understand from yours, that would change your position on the development of the sites, and that would be a material change there to add further dwellings, even if they were minor units, and as they're already permitted, do you think that's something that needs to be addressed with a condition to permit that? Because obviously they're not going to be within the platform anyway. My understanding is that they could be anywhere on the site. Is that correct? So do you think that needs to be addressed as a condition specifically?
My suggestion,
Yeah.
because yes, at the moment, one minor unit is permitted on site, but following subdivision, additional minor units, as well as the additional residential dwelling could be enabled on site. So while it's speculative, it is a permitted baseline, and it could have effect that changes the character of that site away from being rural and maintaining that rural character. And the mitigation that's provided by the landscaping, it's been relied upon to support the proposal and reach the conclusion that it affects no more than one.
This is item number 64 of your report, which is page 13 of your report. You mentioned landscaping protection by covenant. Are you still suggesting that is going to be, that's still what you're suggesting? Or given what we've heard from the applicant, that they volunteered a condition in relation to the development, the replacement of orchard trees in such time. Are you still maintaining that you require a landscape plan, or is a condition going to be sufficient in that place?
That covenants is referring to the landscaping within the Picnic Creek subdivision. Just commenting that I understand that that's landscaping within that development is required to be protected by covenants, and so that its character adjacent land will remain. Provided a landscape plan which is incorporated into the recommended approval. My condition was just suggesting that that landscape plan be updated to reflect some icon of the orchard over time if it's removed. I believe it's a consent notice condition.
Yeah, it is. It's on page 7 of the conditions attached to section 42. Condition 8, paragraph E through H. Is the mitigation plan.
Land use only was proposed, then it would just be a condition of the land use consent. The land use, this consent also approved, then the consent notice condition would be that landscaping.
Just confirmation that in light of Mr. Paulin's evidence, that you've changed your mind in relation to that productivity. And I asked Ms. Copeland in relation to this as well, and I'll ask yourself the reverse sensitivities. Can you please, given that it's a horticultural area, is there anything else in relation to the associated effects should be anticipated? Is there anything further that you'd like to add to that or any conditions?
The consented baseline is already for 2 residential units on the site. Proposed second dwelling complies with the setback requirements and presently well separated from productive activities. The adjacent lot doesn't appear to be used productively at the moment, and the size of it suggests it wouldn't be any significant productive activities potentially. So I have to concern with that progress seems to be this, as well as the fact that it's a rural zone and into where they're going into, but if the land was ever sold, that would be reasonable questions of locating in that zone.
And the only other question that I have is that, and this was dealt with the WSP, are you satisfied that the conditions will, that satisfy standard good practice to those recommendations? And so the WSP report that went into the.
They concluded that the activity was permitted under the NES basis that the levels of copper that were identified were not to present a risk to health. It was noted that there are limits on future earthworks, NES, which would need to be complied with in order for it to remain permitted. But I accept that conditions of that report is it could be advice notes added to ensure that that's reflected on the decision. Need to comply with the NES.
Now, the other thing, can you clarify in relation to the travellers' accommodation that has been consented but not built? under a previous application. Was that, did they have DCs collected for that? You know? Yes, so that wouldn't have been. We can bring that up. And also, paragraph 105. Okay, just, can you just confirm, it just appears that there's some inconsistency between 105 and 109. It just bring those up, please. And your ultimate conclusion that paragraph 109 is somewhat inconsistent with 105.
That being what we were.
Yeah, so the inconsistency, so that's the ultimate conclusion in 109, and it's just,
But
it's
is
just a
that what's
bit.
being changed?
Yeah, so 109 is you talk about, is the inconsistency. And just wanted, can you clarify my understanding between those two paragraphs, please?
5 is referring to the 4.4.2 in landscape character in the outcome sought by those provisions, and I've concluded those that it's not true because those been expanded on by Ms. Copeland. Those policies are effects based, and they talk about avoiding mitigating adverse effects. So the proposal has been demonstrated that it's something mitigated. No more than one. My conclusions and the applicants. The 109 there was more focused on the objectives in relation to activity and protection of the soil resource. And it's just concluding there that because I didn't have any evidence specifically on those matters, I didn't have the certainty to conclude that the effects were less than the finding.
Here.
No. In the legal submission, there's a reference to one of the objectives, 4.3.1, recognising that it's not just about productive lands, that it's social, economic and cultural well-being, and it's been recognised that the application in part is due to finance and restructuring the land to allow that to happen. I'm just wondering if you can give any comment to whether or not you think 4.3.1 actually supports this application, or if that is relevant.
It's relevant to the proposal. I agree with what's been made by the applicant and evidence and legal submissions on that. Ability to obtain funding is really consideration under the RMA, but so the proposal does implement objective or is consistent with that objective, because in this case the applicants outlined that the land is intended to be accommodated by the family, and that family will support ongoing management of that land, and in some cases subdividing and allowing residential activity on land can also allow for improved land management and more productive use of the land than might otherwise be. So I agree, objectives is relevant.
With that in mind, would that have any weight on your suggestion that subdivision be declined? Would that change that?
I think my conclusions were on the basis of uncertainty over the rural productivity leaders and the precedent concern. And I've reconsidered that on the basis of the evidence that's been submitted. And I would be supportive of the subdivision, but I think there's some refinement with the conditions that needs to be discussed.
Okay. Any points of clarification or anything that you recorded? Oops.
Yeah, if the subdivision was to be approved, would the subdivision-like conditions in the land use consent, could they be relied upon at the subdivision stage and not apply to the land use consent? Thinking firefighting, wastewater, water supply.
Is you're referring to the interpretation of conditions. It would still need to be repeated on both in case the subdivision is not implemented.
Right, okay. So that comes up. You haven't got anyone else online that wanted to mysteriously appeared? Okay, so from here, I'm not sure whether you would like to give a right of reply, take a moment, if you need to take a moment. Do you have a room available if you see if you guys need to step out of the room at all and have a discussion, we can accommodate that as well.
Thank you. Yeah, if we could take a brief adjournment, I just want to take some instructions on a couple of matters, and depending on that, that may depend whether I think we can close out today or whether we take an adjournment and address some of those condition matters in writing.
No
Yeah.
problem at all. Right, okay.
So first things first, with respect to the landscaping issue, what we'd like to suggest is that rather than amending the landscape plan, which sort of deals with the orchard as it exists now and everything, that an additional condition is added to that suite of consent notice conditions, that if the orchard is removed and not replaced within 3 years, that a boundary hedge is established and to replace it. And that just provides that window of opportunity to get the trees and do the works necessary to reinstate the orchard, but ensures that if it is taken out, that doesn't just stay like that indefinitely. And then in relation to the question around, I suppose, potential proliferation of residential units, for lack of a better word, what we'd like to suggest is a consent notice condition that would go onto lot 2, that limits the number of residential units on that lot to 1, until such time as the property is rezoned. And if rezoning was to occur, that enables additional residential dwellings, that development can occur in line with that updated zoning.
Just confirming that, so any residential, that's the minor residential unit we're talking about, the
Yeah.
consent notice is applicable only for lot 2. And limits it to 1 until at such time that it may be rezoned.
Yeah. And that's sort of, I mean, Robert and Kevin don't have intentions at the moment, but obviously the district plan is quite old now. We've got a whole lot of resource management reform coming our way, and we don't quite know where that's going to land. But that outcome kind of secures what's been assessed by the landscape assessment until such time as that sort of district planning process may or may not overtake that. And so we hope that kind of, I suppose, provides you with that comfort that, you know, what's been assessed is secured, but allows for that evolution in the event that the planning framework does change. What I can do, if would be helpful, is to provide drafting of those two proposed conditions, and I'd be able to do that by the end of day tomorrow. I'll get through this other hearing and then get back to Duncan and then provide that if it's helpful.
Let's check that would be still surrendering the previous resource consent.
Correct.
Second on lot 1.
Yes.
So you surrender that and you put that condition onto lot 2.
Correct. Yep.
Thank you.
And just in relation to the development contributions question that you raised, Madam Chair, my understanding is development contributions will have been calculated at the time the previous consent was granted, but they're generally not payable until building consent is required, so that the invoice gets issued at that point. So I don't think, certainly they don't recall paying them, which I imagine you probably would recall. Yeah, so I think there's likely to still be development contributions to be calculated with this proposal.
Okay.
From us, unless you have any other questions.
No, nothing for us. So the decision of the hearings panel is reserved, and that the formal decision in writing will be available within the statutory period of 15 working days. And any delay will to you. Yeah, so now the hearing is adjourned. I should have just mentioned, sorry, with regards to a site visit, it would be good to be able to undertake that. Just in the absence of having, is it, are you guys okay with us being able to arrange that through our hearings administrator to arrange a suitable time?
Yeah.
Whether it's today or another day, is that?
Absolutely fine, yeah.
So Jessie will arrange that if that's okay with you guys, and we'll figure out some timing,
Robert.
people's calendars and things. And yourselves.
Can you deal with Robert?
Email me.
That'll be
Yeah.
easiest. Yeah.
Okay, perfect. Okay, right. Thank you, guys.
Thank
The hearing is now adjourned. Welcome, everybody. This is a properly convened meeting of the hearings panel, called for the purpose of hearing submissions in relation to a resource application for a residential activity and vehicle access in a rural resource area and outstanding natural landscape. I will ask Jessie to proceedings to date.
Requirements under section 95 of the Resource Management Act have been complied with. Section 42A report prepared by the planning consultant has been circulated to address for service and all submitters. Submissions received have been identified in the report.
Thank you. And just firstly, I'll just move that the 42A report is accepted. And thank you, Sarah. Now, just as a note, you'll note on the hearing schedule that Commissioner McPherson was due to be here today. Unfortunately, he is ill, so that's why you just have Sarah and myself here today. And also we do have Ms. Kirsten Royce here with us as panel advisor. Kirsten is here for procedural and ground knowledge system panel. So we'll just follow normal procedure today in relation to the hearing, how we're going to conduct the hearing. Panel's going to start with the applicant questions. 42A report writer, and then go through from there. But first of all, I will do some introductions before we kick off. Tracy Patterson, Councillor and Commissioner, and the Chair for today.
Sarah Brown, Councillor and Commissioner.
Tim Rice, Panel Advisor. Betty Dick, Hearings Administrator. Spalding, Consultant Planner.
Craig Barr, I'm a consultant planner for the applicant.
Andrew Duncan, I'm the applicant.
Phil.
Steve Skelton, landscape architect.
And Louise Sullivan, Law Clerk.
And go over there in the back.
Peter Bryce. Nathan.
How do I spell your surname, Peter?
Sorry,
How do I spell your surname?
Bryce, BRASS.
Okay. Welcome. Okay.
We have Sue online as well.
Oh, my apologies. We've got Sue online. Can we introduce? Are you there, Sue?
Yes, yes. Hello, hi. Sue McManaway, and I'm the landscape architect and peer reviewer for the council.
Welcome.
Thank you.
Thank you for that. Now just procedurally, just noting that Commissioner Brown does have a back injury, so if she needs to get up and walk around, she'll do it confined here, but it's just in case she does need to.
Yeah. And also just so the applicant obviously is known to me, Cromwell's a small town. We've got kids in St Hopkins, I think, so effects on their hearing. Just to note that.
Seven.
Thank you. So similar to last time, I just thought I would just run briefly through the legal submissions that I filed, and I suppose highlight what I think are the key sort of points. I think what you will find, and I perhaps come back to a few times during the course of this hearing, is that the proposal is for a residential dwelling in a shed on a 200 hectare site in the rural zone, albeit with a outstanding natural landscape overlay. And it's my submission that it is important to keep that in mind. We're talking about a rural zoned piece of land, as Mr. Discusses in his evidence. The district plan anticipates that rural zones are working environments, and as I've just made the point today, the policy framework within this plan is primarily an effects-based policy framework. In terms of the key issues of contention, I think one of them is obviously around the landscape character and effects, and there is a reasonable degree of consensus, I think, between Mr. Skelton and Ms. McManaway about the landscape effects, particularly at that broader scale, but perhaps a bit of divergence as you come in towards that sort of subject site, particularly scale. The access question and the extent to which the access may require upgrading, and then again this issue of precedent and plan integrity. Terms of the effects assessment, in my legal submissions, I've kind of, I suppose, taken you through what we consider to be the relevant policies and tried to emphasise what I think those policies are seeking to protect. And in my submission, that is the outstanding natural landscapes, but that is the landscapes as a whole. And there is consensus amongst the landscape architects that the effects on the Pisa Range outstanding natural landscape are very low. So in my submission, that means that sort of question of are we protecting those matters of national importance, that is achieved by the application. And what we then turn to is how we might manage the effects of it in that more immediate context. And the proposal, we say, has done that effectively through careful site selection, careful building design, and the proposed mitigations that are included in Mr. Skelton's report. And then alongside that, the habitat and ecological restoration program that is proposed by the applicant and will continue across the wider site in perpetuity, which will support natural character values, enhancement of ecological values, but also maintenance of landscape values through the management of things like wilding pines, which clearly pose a threat to natural character and landscape values within this area. One of the matters I think that you will need to turn your mind to is the weight to be given to views from the legal road that is directly adjacent to the site and effectively traverses the ridgeline between the sort of Cromwell side of the range and the Kawerau Gorge side of the range. I presume you haven't done a site visit yet?
No.
No. So, and no doubt you will. Yeah. So when you do that, I would encourage you to pay sort of particular attention to what that area of legal road is like. You'll notice that it is difficult to traverse even on foot, and what tends to happen is that people who want to gain access up into the elevated parts of the Pisa Range will seek consent from the landowners to actually rely on the right of way, which is a private right of way, no public rights of access over the right of way. But that right of way is actually located on the Kawerau Gorge side of the ridgeline. And so when people are traversing that, the immediate sort of development area is not visible from that. And so in my submission, you can't discount the views from the legal road entirely, but in my submission, relatively little weight should be afforded to those views, given it would only be the most hardy mountain goats that would traverse over that, as opposed to relying on the access track, which is formed within that way. And that approach has been seen to be taken by the courts and in the Royal Burn farming case that we refer to in our submissions. I think cumulative effects is worth touching on. And in that respect, I just want to emphasise that it's only the effects of this application, the environment as it exists today, that is relevant to this assessment. Speculating about what future applications might be made isn't part of your cumulative effects assessment. And so if we were to accept that the landscape is reaching a tipping point as a result of this application, that tipping point, I would say, is not, go over that unless there is a future application, and those effects are not relevant to this consideration. Turning to the matter of access. Now, I think there's no denying that there are parts of the access way that are steep. the applicant has been traversing that access way frequently since they purchased property a number of years ago. And their preference is not to seal the steeper sections. And that is because they prefer the gravel formation, that they feel that it will be safer for them to use, that it will be easier for them to maintain between themselves and the other properties that rely on the right of way. And in my submission, given that this isn't a public right of way, that you should resist being overly paternalistic with respect to the formation requirements of that access. As Mr. Duncan has discussed in his evidence, they understand the access, they understand how to drive it, and they understand effectively what they are taking on. And as the Environment Court said in the Otago Regional Council and Dunedin City Council case, where it is the case, decision makers should resist the temptation to be overly paternalistic and let people be responsible for themselves. The last point is this question about precedent and plan integrity. Now, this is an application for a discretionary activity. The activity status for a proposal like this is the same in outstanding natural landscapes as it is in other areas of the rural zone. And as I've said, this is a proposal for a dwelling and a shed on a 200 hectare rural property. And in our submission, granting consent supports the rural use of the site. And in the context of a discretionary application, I would say that it's very difficult to reach a conclusion that plan integrity is imperiled. On that basis, in light of the effects assessments and a fulsome analysis of the district plan, its objectives and policies, which have considerations of how people provide for their well-being, social, cultural, economic well-being, as well as those effects management policies in relation to landscape character. We reached the conclusion that the proposal is not creating an irreconcilable clash with those provisions, and that there's no barrier to granting consent. Take questions.
Can you just tell me, do you know how many people use that access way? Like how many properties that access is actually for? And then what the purpose would be of people coming through to use the legal road at the moment? Obviously, I know you explained there's a deviation available, but what and who would be going up there?
Legal road. So you basically, you can't use the legal road. And that, there's a couple of reasons for that. One, there's no established access onto the state highway. It partially goes through a dam. So even if you were walking to stay on the legal road, you would need to swim. So in terms of actual physical access over the legal formation, it's really not available. So you require consent from people that have benefit of the right of way to physically access up past the site. in to be able to rely on even that piece of legal road that's directly adjacent to the site. In terms of the numbers of people that might seek to go up there, how many would you?
I can clearly state what's happened over the last 3 years or so.
Yeah.
Right. So I can basically, last 3 years, there's myself, ourselves, and then Dave Aiken, the lease farmer, or the neighbour. Dave goes there, we go there probably the most, actually. Dave goes there once a week, average perhaps, uses it, and it's probably more often at certain seasons when he's lambing, he might be there 2-3 times a week. Then the action. That's it. Sorry, the other, like maybe I'll count them on my hand. So I once met a gentleman up there with a large backpack on his back. He has come out of the orchards below. Oh, excuse me, what's up? And he's like, oh, didn't speak English, and he had a parapont, and he was going to jump off and go back down to wherever his orchard was. So I met a dude walking up the access track. Just happened to be there. Met 2 people once coming back off the Pisa range, coming off the end. They had a vehicle at the bottom. Two younger men in this case, been tramping or something, and they were exiting off. I was like, oh, carry on, man. It's no big deal. And then once the Bannockburn Walking Society called me to say, can we please have access to walk up to Mount Michael, which is the highest point when you can see Mount Michael's the first one. The first high point, I think it's 100 meters, no, 1,300. And they once rang me up and were like, excuse me, we would like to go for a walk up there on Sunday. Sure. And the only time I've ever seen anyone up there is on the farm access track down Vaughan Road. And Bannockburn Walking Society, I suppose they went up there. I wouldn't know. They asked if they could. I said, just got to ring the police farmer and let him know.
Not a well-used track in terms of general public access to walkways or hiking or hunting or anything like that. That would be the preferred access to that range or that area.
We're very cagey about who goes up there, to be honest. Like, it's farming. It's Dave Aiken doesn't want anyone up there. And
he's the lease farm, sorry.
He's the lease farmer, yeah.
And the landowner.
For Hensman on the other side.
That's Hensman's.
He owns the bulk of it on the back side. Like, it's farm, so up there, and we're all pretty. It's interesting. I'll be surprised how aware everyone is of who is up there actually as well. So this is not from lack of. Certainly anecdotally, like I've been up there and my dogs have been barking madly at something, at a possum or something in a rock, and I've got a call and I'm like, "Hi Dave, what's up?" He's like, "Is that you, mate, with your dogs?" I'm like, "Well, how do you know that I'm here? You know, who knows? He's somebody, your dog." So he's really good at it.
I don't think I read that, but just to confirm, there's no appetite to change that legal road or like change the permission through there or anything. It's on a ad hoc permission basis to use your land, but you're in principle still happy that the arrangement that is there now, that road being actually unusable by the sound of it, you'd be happy that continued, that arrangement, regardless of what happened with more access further on to the property.
Are they anticipating that seeking that the legal road be formed?
Oh, from what I understand here, the legal road being inaccessible requires people to ask for permission to use the right of way through your land. You don't see that changing with what you're doing there. You're quite happy that continues, that arrangement as it is informally.
Yeah, the people. Yeah, for sure.
And perhaps just to clarify too, that the right of way isn't located on Andrew's property, so it's just he's got the benefit of it, but it's actually located sort of a bit of a mixture. But not. Is my understanding correct that because that road is largely unusable in those parts that you've described, that to access higher ground would require access onto your property to get round, so there is an alternative route, as it were, or through private land, or is that so the access way alongside Andrew's property actually stays on the Double Rock property and dips down on the Kawerau gorge side of the ridgeline. So that the unformed legal road basically traverses up the boundary of Andrews Place along the crest of the ridge.
Yep.
But the formed access way, where the right of way exists, is on the Double Rock property, but on the Kawerau gorge side. So people sort of come up to almost the corner of your place, and then it sort of dips down onto the ridge line and then up into Double Rock before it gets up into the conservation land further above. Yeah.
And I think some of this will become quite apparent
Yeah.
on the site.
Yeah.
That's it. I'm just trying to understand the usage. Obviously, I mean, we're giving way to the views from the road.
Yes.
But it's important who will be getting those views and who's going to be using it and how busy that actually is. What it does. That's good. Thank you.
I mean, there's always and there's always some there's the walking access people, and some people are very diligent about maintaining use of the unformed roads because they want to exercise the rights that affords them. So we're not suggesting that it is impossible that someone would seek to traverse the unformed road, but what we know from practice is that most people look at where you have to go and how much Metagara you have to get through and go, yeah, I'm going to stay on that access track. And most people also recognise that that access track is actually located on private land and seek permission. Not everyone, as Andrew's explained, but most people do.
Award for asking us to go up the track. Don't bother with that part.
Thank you. It's quite hard sometimes. The site visit will help a lot, but just clarifying what the little black lines are on them.
Yeah.
Sometimes.
And when you see the little water storage reservoir, the road runs through that. So you can assess how likely it is someone's going to dive in to stay on the road.
So what, can you tell me your understanding of the legal position of an unformed paper road is in this case, given that there is some, like the physical barrier of a water reservoir being right in the middle? What's the legal position? And especially given that probably a lot of roads that have unformed, have some barrier in relation to that.
Yeah. So, I mean, the legal position is that the public have the right to use unformed legal roads, and we're not denying that. In terms of your assessment under the Resource Management Act, what I think it means is that you need to evaluate the weight that is given to the effects that arise from that viewpoint based on what the real world looks like. And the real world in this case is that legal road is impassable. And so in my view, that means you shouldn't totally discount the effects from that legal road, but you shouldn't overplay that either. And so recognising that the majority of people that will seek to gain access to the elevated parts of the Pisa will rely on the formed access. And so what views are available from that formed access should be given more weight than the views that are available from the unformed road. But I'm not suggesting that you ignore those views entirely.
So I'll come back to that one different. So with there was the other resource consent 230728, and this was on, I'm just wondering, did that right of way in that building get constructed under that resource
This is
consent?
the Double Rock hut.
Yeah, I think so. I didn't know.
So there were upgrades to the right of way required for that consent. Has Grant done those yet? Yeah, so those have been completed. And is the hut under construction? Not yet. I think some earthworks have been done, but the actual hut hasn't been built yet. There's of course a boundary adjustment subdivision that was consented as part of that.
Now, just in relation to, you've mentioned in relation to the roading and the ceiling, we do have Walt available from the council team to come in. I'm just wondering when that would be, when you guys when would you think that would be appropriate? I'm just wondering whether that might be, Craig, do you think that would be under, to get Walt in relation to the roading side? Just, I know he's available.
Yeah.
But he just needs 5-10 minutes for us to say to him, for him to come in. Do you have a particular time that would be more suitable for?
So it would be after the applicant team's concluded and perhaps when Emma's talking to her
At that point then?
information. Does that sound about right, Bridget?
Okay.
Yeah, we don't have a traffic person here specifically for them to listen to any more than what we've already seen with our information.
Happy with that? Okay, well, I'll just let Jesse know when we get to that point, that we'll just give him a bit of a heads up. Yes, yeah, possibly.
I'll let him know.
I'm just conscious that we're meant to schedule lunch for 12 o'clock, but we've only just started. So just was in the second here. Do we want to have some kind of agreement just to keep moving on? Are you guys happy with that rather than stop starting? But we only just began.
The snack. I'm
Yes, okay. And you're okay with that, just to keep moving on? Okay, and my team, you guys are all good? Okay. Okay, so we'll just keep moving on. Okay.
It's not too.
The matter of precedent.
Yeah.
When we look at this application, obviously being in an ONL area, it you satisfy my concern as a panel member that we are in relation to an elevated, concern level because of the nature of the ONL. Just want to hear your thoughts.
Yeah. So I think, I suppose where I start with that is that, all applications need to be treated on their own merits. That's the starting point from a resource management point of view. They don't create precedent in a strict sense. Then I look at the district plan framework itself. And as I highlighted before, a proposal like this is for a discretionary application. So you may grant, you may decline, you may impose conditions. But the rule framework doesn't suggest, I suppose, that a proposal like this is on its face incompatible with the outstanding natural landscape. And when you look at the policy framework, you see that there's an acknowledgement in the plan that that rural zones and even areas that are outstanding are still likely to be working environments and that people will use them to provide for their social, economic and cultural well-being. So that's the sort of framework I think that I start with. Then I think you need to look at the policy framework around outstanding natural landscapes, which kind of, I think, seeks to emphasise the sort of key parts of those landscapes which need to be carefully managed, avoiding prominent ridge lines and that kind of thing. And clearly directs you towards managing effects. And what I would say is that that's what we've done here. Andrew has been very thoughtful in the site that he's chosen. The building design is sensitive to the environment within which it sits, simple built form, dark colours, all of those kinds of things. And So when you take that, that framework and look at that working environment and the need for people to provide for themselves and those landscape matters, then it all fits together. And I also think that the policy framework, and it goes to my point about thinking of the, I suppose, the different scales. The direction in section 6 is about protecting landscapes. And in the Central Otago District Plan, obviously, we've got the Pisa Range landscape. Now, it's an extensive area. And I think, as I drew your attention to in my submissions, you know, there's a huge amount of elevation within that outstanding natural landscape. And so there are going to be parts of it that are more developed, that are tend to be more working landscapes. And then as you get further up, of course, you get into those areas that are much more, I suppose, free from built form, that are more remote and all of that kind of thing. And so in my view, the consensus amongst the landscape experts is that at that landscape scale, X are low. And in my submission, that means the landscape values are protected. And so you have, in that it's done what section 6 requires and what policy framework in the district plan requires. And so then you get down to that, I suppose, more defined kind of scale. And we are avoiding the parts of the landscape that the district plan picks up on, the prominent ridge lines and things like that, and have done what that policy framework anticipates in terms of utilising topography and managing visibility and all of those kinds of things. So it's my submission that the proposal has picked up on all of those cues from that framework, and having done that and managed the effects, that the precedent issue doesn't arise. If anything, this is exactly what is required of an applicant seeking to develop in the outstanding natural landscape.
I guess that was confirming that is an argument to what you said earlier in relation to that speculative
Yes.
perception.
Yeah. I mean, a future applicant, I suppose, would have to find a similarly confined location, you know, and do all of the things to manage effects. And they'll need to do that in their own right. They won't be able to point to this site and say, well, they did it. To figure that out for themselves. So then I will just get Andrew to speak to his evidence as the applicant. The things you want to highlight.
I tried to think of a summary, but I'm pretty happy with what's written here, to be honest. It's all there. This is all important to us. It really does state quite well what we've been doing for about, including my little letter that I actually sent to council back on the 3rd of March 2023 or 31st, whenever it was, March 23. I wanted to put that in too, because I'm just like, oh, that was me thinking very hard at the beginning of this process about who we were as well, knowing that it's discretionary. And just, yeah, please ask me any questions that you have. I'm really happy to talk about the access stuff while I'm here, but it's not, that's something I've been thinking about, or the process I went through to design the house or whatever it is. We've been trying to do as much as we can ourselves. To answer questions, really. I've said I'm happy with this.
As read. You can make this as read.
Because you usually cover Oh,
Yeah. So, obviously I just wanted to traverse with you a little bit about, the elevation and how did you come to that, reasoning of wanting to be up at 680?
The nose glances.
Yeah.
So we purchased the property, when we actually came, as I think we had a look at it. This is the best access to the property, existing, without being on foot. So we went up there with the land agent, ran up and actually was like, oh, there's this little spot there. It's interesting. That could be useful. So it kind of chose itself. It called to us in that respect as a good spot. So could have been much higher if that was what we were after. It goes to 900 meters, our property. So, but it's really nicely located in the middle of the property actually, and you get on a little bit from being stuck down in the corner where you initially hit it coming off the access track. So you get out onto it a little bit. So you're nesting in the middle-ish, which is much better for access and everything else. You get this little valley, and all the lower stuff is still O&L anyway, and it doesn't have the same kind of, it doesn't have that little nested little valley, isn't any lower. All the lower stuff's a bit more exposed, and you kind of look at it a bit more. So the landform pulled us to that spot, and the elevation wasn't even a consideration. Like I didn't think it's high. It's high. It doesn't feel that high to me.
Haven't had any, since owning the property, you haven't had any, especially just since we're in the middle of winter. Have there been any alternative thoughts since then?
No, I mean, it is colder there, but not by much. And, the Ripon Vale below gets as cold as anything down in those lower areas. And it's not, if by saying that it's, that it's actually not a bad spot. We've been there many, many times, and you can see how the wind patterns interact to that little valley. It's actually quite sheltered. It's like a good animal camp. You know what I mean? Like, there's some good landform shelter there, actually. And we were renting in town, it's really different, actually. It could be howling away down there, coming off the lake, and you go up there and it's like, oh, it's completely different. So although you think, oh, it must be worse up there because it's higher in every case, it's actually, for some reason, it can be better depending on the wind direction and, slightly colder. That's not, it's our first kid's name is Kia. We know that because you're in the South Island when you can see them. We're not in the Kaimanawas. We're not in some other mountainous area of New Zealand. Definitely in the South Island. So I'm not, elevation's not an issue to me.
So in relation to the balance of the site, should we be in mind to grant this? Is it? I understand that you've got this leased at the moment. For the balance of have you got any other alternative ideas of what you're going to be doing, or is it going to be continued to be predominantly agricultural based sheep farm? No other anticipated uses?
No, I think it's a good enough to be a small farm, of the size that it is. And other than, like, the goal is to make it better than we found it. Like, we're pretty keen to plant anyway. We're always keen on that. Like, lots of these gullies look really quite right for that kind of idea. You can get in there and establish amongst the Matakari. It's actually pretty, once we get some fencing happening. But yeah, we can, like being in Cornish, our neighbour, if we need to, they grow some of the finest merino around there. And if we can sort of attach to that, that industrial scale farm there with our small flocks, if we have them, we just muster down out of there. It's like they would literally share a large fence line. So I think it's, without you know, without, we can attach to that system that they have. And other than that, no, it's just a place to explore really, and for kids to grow up and ride their horses and have any other real great ambitions for it, to be honest.
Possibly, because I'm not sure where it is, but are there any high profile poles for the building up
Yep.
on the site at the moment?
About 10 months.
And they're still.
One's fallen over.
We've been to a few sites where they just snapped off at the base and they're not good, so they're all where they should be. And
Yeah, I've got, my horse has knocked one over about 6 months ago. I need to put it back.
if we do conduct a site visit, part of that would be on
Yeah.
the visuals from outside of the site as well as on the site. So it's really important that those.
They're actually at the height of cable too. So like that's it's you know, reality, give or take.
And that's based on the house plans, that 6-bedroom dwelling that's there. That is, as part of your application for that exact building, you're quite happy that that's your confirmed footprint. So the heights, the roof,
Fine.
that's we're moving forward with. So
Yeah.
it would be granted on the basis of that particular build.
Yeah. I'll change our minds at this point.
Bedroom.
Huh?
Not going to add another bedroom.
We may have to reduce them after the course of this exercise. But we'll see.
That's, okay.
Thank you.
Steve.
Sure.
Any comments?
Yes. I'll just provide a quick summary of my evidence assessment. Thank you for having us today. As was discussed earlier, this is one dwelling in a shed on a 202 hectare property. The shed and the dwelling have been well located in a shallow depression. When you go up there, you'll see, and then there's a rocky knoll to the east, which provides quite a bit of screening. And I think Mr. Duncan will tell you when I first went up there, I said, you won't be able to see anything from here. He said, I know, he just wants to live up there. So it's not about exploiting the amenity, the views, which a lot of dwellings are. This is about tucking a residential dwelling into the landform. So visually, from the valley floor, when we were undertaking our visual assessment, Mr. Duncan was up there running around with his vehicle, a white Land Cruiser, and I was using binoculars to try and spot it, the vastness of the piece of range, to figure out with all of these undulating humps and hollows where the site actually was after being there on 2 separate occasions. Was difficult. Finally, when I'd see his vehicle, then he'd go to a pole and then stick it up so I could see where the pole was and then put it down again. And then we were, and then I had to mark it on my, it was a process to figure out exactly where the site was. So it's barely discernible from the valley floor. Our visual assessment goes, to the opposite side of the lake, to Bannockburn, and from the urban areas of Cromwell. So my assessment is that there's very low adverse visual effects associated from the valley floor, and that it's extremely difficult to see. The only thing that might highlight it would be in the evening, a diffuse glow. So not like a filament of a light. You may be able to see something in the future up at the very top. It will be visible from that public road, which we've traversed already quite a bit today. When I was looking at that, I did walk the public road, which is on the opposite side of the fence, using a GPS tracker on my phone to make sure that I was on the road. And it's heavily vegetated and tussocks and matagari and porcupine scrub, so it's hard to move across that. There's limited evidence of people using it, and it's was discussed earlier. The actual right of way is below on the ridge, or below the ridge to the west of the fence line. So it's likely people are using that, even if they're not there legally, bear ponting, as we heard, that they're likely going to be on the right of way. And just in that discussion, if I could sort of diverge from where I am here too, I was looking at the WAMS maps to access that piece of conservation area. if you were to do a full traverse of the Pisa and want to come out from the south or access north to south, you can go up the Roaring Meg and then head up to the ridge line, which brings you up towards Mount Michael. So there is public access to the wider Pisa up the Roaring Meg and then back out towards the hill. In terms of character effects, when we're talking about landscapes, yes, I mean, the wider outstanding natural landscape is the Pisa Range. There's two main varying characters of that. There's the upper plateau of the Pisa and then those eastern facing slopes. And then within that are smaller character areas as well. To assess effects. In this instance, we've looked at breaking it into the southeastern slopes, which are basically below Mount Michael, towards the edge of the lake and back towards the cow route. So it's a landscape in its own right, but it is part of the wider outstanding natural landscape. I've assessed that within the development site itself that there would be moderate adverse effects, and those are on open character. And that's by virtue of there not being any buildings there now, and there's a proposal for there to be buildings there. So inherently that would have an effect on open character. When I was first approached with this project with Mr. Duncan too, I said, well, there has to be an offset, there has to be some give back because a building there will have an adverse effect on the open natural landscape. And I've set out what the landscape management plan might be able to employ to provide some enhancement for the outstanding natural landscape in terms of removing of wild and conifers and a 7-year eradication program, planting of what we'd agreed to 500 indigenous plants a year, as well as ongoing pest and predator control. So that would be ferrets and stoats and rabbits and the like. And he does have 4 sons. And that's the sort of thing that he wants to do up there. So I have some faith that the enhancements that I've relied on in my assessment will take place with the granting of this consent. The main difference between myself and Ms. McManaway, which we are aligned in a lot of our thinking. We agree that there's limited visibility from the valley floor. And that the effects on the wider outstanding natural landscape will be at least low. But we do disagree on the weight given to the view from the public road. And it was my assessment that even if you are considering visual effects, that they would be high from that location. That really it's only a 150-meter portion of it if you're walking on the actual legal road, because landform starts to intervene and it becomes further and further distant. So there's about a 150-meter section of the legal road where if you're looking to down towards the development site, it would have that adverse effect. And we also disagree into the weight that should be given to the landscape management plan and the enhancement that it will secure. So overall, I consider the proposal on whole will maintain and enhance the outstanding natural landscape and its values. As I'm here to take any questions.
In relation to the planting plan,
Yes,
especially, I guess not necessarily the planting plan that is located closer to the dwelling, the proposed dwelling. I'm talking about the broader planting plan. What, if any, irrigation has been what I've replied in relation to that plan,
right.
or is it natural?
Yeah, we did discuss this earlier. There's a few gullies that run through the site. Those would be the ideal locations to implement the first amount of planting in those gullies, generally south facing areas, which will retain more moisture. So as part of the condition of consent would be the lodging of a landscape management plan. We haven't prepared one. We've just prepared the broad ideas that that LMP should follow. So it'd be saying, well, okay, here's all of the site. Here's the south facing slopes at a certain elevation. Here's the areas that we have ephemeral water courses, and identifying those areas as being the most appropriate for doing planting, and then looking at the types of species which would be most appropriate to go in those areas, and then providing for rabbit guards, irrigation, mulch matting, slow release, controlled release fertilizer, those sorts of things as a best management. If you're planting the appropriate species in the right location, then irrigation will kind of facilitate the establishment, but it wouldn't be necessary for the success of the vegetation. So in terms of the broader LMP, where irrigation could be provided for, it could be something that we could write in. I'm not sure how much water you have.
There is sufficient water available from the take, and there's ways of getting it around too. But we'll have to choose the spots.
I think the getting
And
around,
there are seeps as well, you know, that we can utilize. Yeah, like you say, like somewhat not ephemeral, but
the getting it around, the conveyance of the water would probably be the difficult part. Mainly for, you know, if there's any trenching involved, that would sort of defeat the purpose of landscape enhancement. But it's my experience in these areas. I mean, we're talking tussocks and grey shrublands, as well.
So
as
predominantly dry land restoration.
That's right. Yes. And we would seek advice from an ecologist, or at least refer to other ecological documents in the area that provide those endemic species and the best location for those.
Or on that basis, if you're, I mean, from the visual representations that we've seen so far, as in what's existing there now, there isn't anything other than some undesirables, arguably, in relation to the wilding pines, which you've identified. So how is it going to look? How can you satisfy me that it's not going to be a significant, once these potential plantings have grown, it's going to be a significant departure and perhaps more of a visual effect from further away because of planting,
Yeah.
when it is now already a pretty, by your own admission, it's a big open landscape.
So like a mosaic or a patchwork of.
Yeah, so essentially all of a sudden you've got a big area that you can see being planted.
Hmm.
So it's almost like the reverse of what,
And if-
I understand what you're trying to do, but how will that have an effect? Positive or
in a
negative?
visual sense.
In the visual sense?
Yes, I think, well, we are talking about a 202 hectare site, and the type of vegetation that would likely be proposed, because double check, would be your carokias, your coprosmas, flax, and different types of rushes and sedges, and grasses, which actually will fit in with that pattern of what's there, because there is a lot of porcupine scrub and matagari and briar, and maybe some brim and gorse, I'd imagine. So that the pattern and texture and color of the weed species is similar in what you'll find in the endemic vegetation. I think the potential visual shortfall that might be there is when you have 500 new plant protectors. That ends up having a little bit of a visual effect, especially if they're the green ones. So the cardboards and the tawny colored plant protectors would fit in better in that landscape. And we are talking about patches of 500 plants per year. So it'd be dispersed over time. And in, say, 10 to 15 years, that 202 hectare site could look a little bit different, but that would probably be a positive thing to encourage other people to do the same thing. And I don't think that it would really detract from the visual values of the wider landscape, especially if people are informed and understand what they're seeing. Because, you know, it's a classic. If you look up at a conifer forest, say the hills above Queenstown, or on your way to here in Queenstown and the Carroll Gorge, you look up and now you see a dead, you know, forest, a skeleton of trees. But that's actually a positive effect in terms of natural character and ecology. Visually, it takes some time for that to settle in.
I'll just make sure. Now you mentioned about the blow. I'm not sure whether this is for you or Mr. Barr, but either one of you, maybe Mr. Barr will pick this up at some point if it's whoever's it applicable to. You haven't done a light assessment,
No, there is a
Yes,
light
it's-
assessment though, yes.
but there is,
There is the lighting, there's a lighting report,
yes,
that provides recommendations.
but it's not an in-depth one, which will, no, okay.
Now, when I'm working, if I were to be writing lighting controls and something like this, it'd be, down lighting 1.2 meters in height, at a warm temperature. I think it's 2,400 kilohertz. No, I'm not a lighting expert,
Yeah.
but at a warm temperature. And to ensure that any filament is diffused, that all the light is diffused. So what that does is you never get that twinkle. You never see a twinkle of something off in a distance. It's more if you were to, point out to somebody, oh, you see the stars up there in the moon. It's sort of down to the left. You see that's where the house is. So it's still meet that reasonably difficult to see. So it's a diffused lighting.
And I guess the reason why I'm raising it is, and you'll no doubt be aware that we do have dark sky locations within Otago, and there has been a push for that dark sky in some of these applications that are coming are in relation to making sure that that light spill is a critical component, especially when you're dealing with an area. So I guess we just need a clarification from you that the light spill element is not going to be significant if the proposal was.
It would not be significant. I think Mr. Duncan might be able to point you to more detail around the lighting report.
There was a company that produced one for us, and they had trouble even understanding what I was asking. With respect, it's like, how far to the boundary? Oh, wow. Sorry. Any visual acuity is like they're more, it's so far and there's so little light and it's down light, and they're like, they can't even, they find it very hard to calculate what we're talking about. And in terms of, whether you'll, like it's well beyond right at the extent of human visual acuity to see anything that far away from the site boundary anyway, let alone the fact that it's landform encloses it. It's pretty hard to imagine.
What you're
being
saying is that there's no, let's say you had all the, let's say, for argument's sake, the lights were on
Yep, everything.
and there was no curtains.
Curtains, yep.
See that light from some of those viewpoints.
It's really,
Other than I accept what you're saying, we're not talking about that part on the
Yeah.
50s.
Yeah, so I think there's a couple of parts to that. One is the landform again, and I think in the original, so there've been two applications just by way of background. One was, and there was an assessment done where I think you stood up with a floodlight on a stick and tried to figure out could it be seen from anywhere, and so where the lighting is on the house, we are satisfied, I suppose, that that's screened by landform. We have also, in the proposed conditions, adopted the sort of standard dark sky controls, so down lighting, the colour that Steve's referred to, and lighting heights and things like that, so that we're working to absolutely minimise the potential spill. I think we've got real confidence that in terms of the district plan standard around light spill, will comfortably comply with those, and then have adopted that additional layer of utilising those dark sky requirements, which are quite, they're pretty common now. I think, even in urban environments, people are tending to utilise those in residential areas and things. So I think the combination of all of those things, we would say that lighting is managed adequately.
Keen to just explore a little bit more of it. Where you said there's positive enhancements with the planting plan or the conifer occasion, those kind of things, that the stewardship of the land is benefit. I'm wondering how much weight we should be putting on that, as opposed to we've acknowledged that there is an effect on the ONL. There's scale of where the property lies within that is of discussion, I guess, but if you could just give me an overview of how that's going to enhance that, what that's going to do and how that offsets that ONL effect.
Well, currently, no one's living on the site. And I believe it's grazed periodically. So there's limited care. There are wilding conifers at the base of it. Some of them are of seed producing age. So there's quite a few actually at the lower parts of the site. So as they mature, the more spread that will continue, not just on the site, but generally, I guess, further south, to be honest, with the wind, they spread with wind. So the removal of those is a significant positive effect in terms of the pest species in the regional district. There's quite a few plans been drawn up on controlling the spread of wilding conifers and other pests. So that in itself has a positive effect in controlling the spread of weeds. Because at the moment, there's no onus on any landowner to do that. There is one policy: if your neighbor or dog clears next to you, you should clear within, I think, 200 meters of your site. But I haven't seen that really enacted, the good neighbor policy. So there's no reason for any landowner to clear wild conifers. That's one positive effect. And then by simply planting more endemic species, I mean, most of Cromwell, at least, a lot of it was broadleaf forest back in the day. So a lot of that's been burnt off. There's still a handful of old co-fis floating around, but there's not a large seed source. So when you're planting 500 species in groups in appropriate locations, that then, there's 500 and they're in the right spot, you might end up with 350, 400 survive. It's still quite a really good patch of indigenous vegetation. That then creates a seed source to spread further in other parts of the area. So if you have a south-facing gully, it should continue to spread throughout. So that then provides more habitat for birds and lizards. Birds need there's a matrix of source populations and islands and smaller patches of vegetation that they need to travel. So if there's a wider source population, which I'm not an ecologist, but and then they know that they've got 500 plants here, then they know that they have a place to go. So it encourages bird movements throughout the district. So it actually has wider effects beyond the boundaries of the site. And then the other bit was pest eradication. So we'd have to look at, when we're developing the LMP, how far to go with that. But I think that Mr. Duncan would be willing to have it proof fencing.
No, we actually don't have a rabbit problem up there at all. So there's the odd here, but they're all shot out.
Yeah.
And we took 30 goats out of there 2 weeks ago.
Goats,
Yeah, I mean,
ferrets and stoats.
goats are a problem
Right.
at the moment.
Wilding cats.
Working on that.
Cats are going after the lizards. I'm sure I'm not a ecologist again, but I'm sure there's a good lizard population up there, seeing all the rocks. There's probably places for lizards. So there would be provisions for the control of those types of predators, whether it be traps on site and then further afield, and then maybe monitoring of that over time that could feed into a wider understanding of the predator spread in the district. There's lots of different ways now to monitor those and have it become a wider cloud-based pest eradication network. So that's stuff that we could write into the landscape management plan. And I've written a couple of these. They're quite robust. They have a lot of backing in them. Do a lot of research, and we do get ecological advice to see what the best way to pursue these in certain regions area that we're working in. So that could be informed by an ecologist, and then also sanctuary providers and pest eradicators. To be honest, I think wilding cats might be feral cats might be the Sure. That's
Yeah,
good.
the goats really.
Would you consider that a condition would be appropriate to ensure the enduring the mitigation and the plants and the pest eradication? Like obviously getting on site, establishing the site is one thing, but something just to ensure that continuity within, I don't know if that falls in the landscape management plan or if that's outside of that, but I'm hearing that there's positive effects things that are part of this, the work that's being offered. So if that's a consent condition in there would be appropriate, just to ensure that that did endure.
Yes, yeah.
That would work.
I think it's already,
It's
been proposed,
in there,
yeah.
but with the time of that, with all of those things, we're happy that that's going to provide a positive enduring effect through the ONL specifically. That's what I'm reading there. Yeah,
Yes, yeah, I mean,
just want to clarify that that's.
I say Mr. Duncan plants for 6 years and then something happens, there's nobody there to care for the land. Even the planting over that 6 years, which would that be, that'd be some 3,500 or 3,000 plants. That's a pretty good number in different locations too. So we'd be looking to do them in patches. That would in itself have a positive effect if it was just that. That would have an enduring positive effect. I think the ongoing wilding management, do that over a period of, we're saying every 7 years, do that over a period of 3 cycles. Probably the end of the wilding conifer problem, at least on the site, so it's coming in from neighboring sites. The hope is that that's well taken care of next about 21 years. So yeah, I think even just by the planting alone for a period of time would provide an enduring effect. The ongoing management of that is something that would have to be conditioned and written in it and adhered to.
And if I remember right, a survey that you did mention earlier, that was a condition in perpetuity.
Yes, yeah, so there's it's condition 18 is the landscape management plan condition. And that has the requirement that so there's the sort of, I suppose, 2 parts. There's the mitigation planting, which is sort of around the building itself, and then there's the other Indigenous vegetation planting. The wilding control process is to occur on a rolling 7-year cycle. So that's an ongoing obligation for as long as the dwelling's there effectively and the complete health conditions in place. The pest control methods around possums, rabbits, mustelids and feral cats. I'm wondering if we should be adding goats to that in light of the goats problem. Yeah, cats is in there. And then the planting strategy is to be implemented over 10 years to support native regeneration within the site. And so that requires 500 plants per annum on average over 10 years on the south facing slopes and gullies, and then the management of those, including monitoring their survival. So we'd say that that's a enduring kind of plan. We could perhaps, if you're concerned about it beyond the 10-year kind of period and the plantings, we could potentially add another paragraph in there perhaps to be a bit more explicit about that ongoing management once that planting is complete. The only thing, look at that again.
Yeah, I mean, you put a building in and you tick a box that says it's going to last at least 50 years.
Yeah.
And obviously just balancing those. What I'm taking from the evidence at this point is that there is obviously an effect on the ONL building itself. We're seeing some positive effects from what comes habitation of that section, and it's the balance of the two. And if there is a net positive effect from all of these mitigation measures and planting, etc., then just making sure that does continue for obviously the life of that building itself, but that net positive effect then is real to give weight to.
Okay, I just anything further?
No, I'm good.
I just have another question in relation to, just wondering where I've put it. Bear with me. Gracious. The visual assessment, once the road is potentially or parts of the right of way be sealed. Under the just recommendation, the engineer's recommendation was that anything over the 12.5% would be sealed. What putting that, if that was put in place, what would be the visual assessment of that?
Sealed, are we talking
As in
concrete?
chip seal.
Chip seal?
Yeah, as in the proper tar seal, I guess.
Yeah, well, chip seal reads quite often as gravel. It does depend on the aggregate that you're putting in the chip seal. I'd imagine this would be locally sourced, which is probably like a darkish brown. So it'd have that the aggregate and then the bonding agent. It does read very much like gravel when you look at it from a distance and from close up. So chip seal will often specify in rural environments gravel or chip seal, no concrete, no asphalt. So it would still have that rural appearance.
And if it was asphalt?
Asphalt's pretty dark, so it's more recessive from such a distance. It's, I think the visual effect would be quite similar. The one thing I'd be concerned with that often engineers end up doing is specifying that we have to have a concrete nib to to change the stormwater, and that in itself can end up reading quite white and have a visual effect. So that'd be one thing that I'd be concerned with. But asphalt, yeah, it is more recessive, but it's less rural in appearance.
Less, it would just be essentially, it would be less compatible with a rural environment. Is your assessment?
Well, I think from the distance that it would be seen, which would be over 3 kilometers, if seen at all. Really. And if I'd known exactly where these 12% might be, it would be a bit easier to understand. But I think if you were to look at it in the worst case environment of where any asphalt might potentially be seen, I would prefer that it was a chip seal to maintain that ruralness. Even if it was a lighter color and potentially more visible, the chip seal's character.
Then that the road surface, albeit in parts, is negligible in your mind as to what that might be. It doesn't have a huge effect either way visually. So the road surface were really determined by access and the engineering. That's the next one for that. That
Yes.
my understanding is correct.
Yeah. There's farm tracks that you can see. It would read generally like a farm track.
Thank you.
Right. Okay.
Great.
I've just got a summary to hand up. You see? Yes, there's some copies here too if you want to read them.
Just a little follow-up on that discussion around the access. And Andrew, you may be able to add to this, but my understanding, kind of potential issues with the ceiling is the additional demands that it creates for stormwater management. And that means that there is additional earthworks and things that are required to construct that access way and put that ceiling in and then manage that stormwater runoff. So there might be additional effects that arise from the ceiling requirement created by the fact that there is more engineering requirements that sort of triggers beyond the sort of current formation because you're not having to manage quite so much water runoff with a gravel access.
And I'm sure we'll engineer and he'll be able to talk to that as well.
Yep.
And I could prepare some controls on how to address those from a visual and character effects. If there are some engineering requirements, screening, regrassing, how to treat spoil, that sort of thing.
That Tracy had about long-term effective planting. They tend to go in the gullies, isn't it? Well, so, no, it's probably a bit of trouble.
Mr. Barr.
Thank you. So I have a pretty short one-page summary statement I'll just talk to, and then I have just a response or some graphic aids for the discussions that have been had today, and then I'll be free to answer some questions. So just a paragraph back to my summary statement. So paragraph 1.2 there. Just summarising that the key matter of contention relates to the appropriateness of locating the residential activity, which is a dwelling shed, and the 2,000 metre squared curtilage area and access within a part of the district identified as an outstanding natural landscape. My evidence is that the activity will be appropriate because the adverse visual effects are low or to low moderate at worst, as described by both landscape experts. I hope I have that right. The only area where the activity is really visible is near an unformed road that is not practical for general public to gain access to. That's been talked about in depth today. The proposed mitigation and development controls will be effective at avoiding or mitigating visual effects, and wilding tree removal and ongoing Indigenous vegetation planting will provide positive landscape outcomes for the site. At section 1.4, my evidence sort of summarises the concept that the landscape effects overall must be considered in the context of the policy direction of the district plan, which in determining what is inappropriate requires recognition that the outstanding natural landscapes are often utilised by people and communities for their social, economic and cultural well-being. And lastly, the ability for the applicants to reside on the site and undertake positive land management practices in conjunction with the proposed landscape management will achieve the intentions of the district plan's management of ONLs and achieve part 2 of the RMA. So that's a quick synopsis of my evidence. Now, I have just a couple of matters to talk to. Now, do you all have a copy of the agenda in front of you on your laptops or iPads? Okay, so I think I got the page numbers right. Just in relation to access, I take you to page 333 of the agenda document. What I'm taking you to, sorry, is the assessment of effects on the environment that was lodged with the application. And that's got its own page, but I think what you really want is the agenda reference, right? Yeah, I think. So what that is, that's a discussion in the AE that was lodged around access, and it just illustrates exactly what's been talked about by the applicants' representatives today. So figure 6. So yep, looks like we've landed on the same place. So figure 6 is the start of the access, and you can see the irrigation pond that's been built over the portion of unformed roads. That just illustrates what was talked about there. I think the red line is the yellow. These are excerpts of the district plan map. So the red line is the rural lifestyle zoning, and the yellow shading is the rural resource area, and the clear is the road parcel, because the roads aren't zoned. And figure 7 is from the pond, heading up into the site or along the right of way, and you can see the unformed legal road and the existing track in relation to it. And on the next page, figure 8 is probably quite helpful, that it shows the western boundary of the site, and it shows the unformed road adjacent, abutting it, and then it shows the access track. And existing huts there for reference, and the location of the proposed dwelling, general location is there for reference too. So hopefully that just describes what was talked about today in terms of, unless you had a sort of GPS in your hand telling you exactly where the unformed road was, you'd be lucky to stumble upon it, really, wouldn't you? I mean, if you're, compared to the access track, and then there's the elevation goes up to the boundary. So that's sort of just describing the sort of practical location of that unformed road relative to the site and relative to the access track that's on the adjoining land. And just for context, figure 9 on that same page is a copy of the approved scheme plan for the subdivision boundary adjustment and building platform, Double Rock, I think it's called, application, or RC 230278. And that actually shows the location of the approved building platform, and you can see the sort of footprint of a 3-bedroom cottage house in relation to an unformed road. So you can see the 20-metre wide, or about 20-metre wide unformed road, and the access going through it, and the proposed access. And when you do your site visit, you'll see that that access has been formed. You'll see the sort of horseshoe shape by the road. Yeah. So that's hopefully just some graphic aids that were there, that was being talked about today. The issue around precedent's been discussed as well. From a practical, I'm not going to sort of redo that, but from a practical perspective, if you go to page 349 of the agenda, you'll see figure 12. And that's part of an illustration that's in the part of the AE called precedent effects, which I'm not going to repeat or sort of talk out to. But what figure 12 does do is that it shows that from a practical perspective, the sides of the site and the adjoining land, and what's happened on the adjoining land, to the best of my sort of desktop ability and investigations to see what other development has occurred. And so what I think this illustration might do is sort of explain that the likelihood of this activity, were this activity to be granted, the likelihood of a whole sort of raft of similar applications following are relatively limited, because all the adjoining sites of large parcels of land that, except for the young property in blue, have dwellings on them. And then you've got a rural resource area zoning east, and on the following page, figure 13 shows a existing sort of rural lifestyle dwelling on sort of oddly shaped parcel of land, but it already has a dwelling on it. So the point I was trying to show with these illustrations, and I think it's still relevant, is that it's not like there's a whole lot of undeveloped 20-hectare properties adjoining the site that were surveyed in the 1890s that are owned by different people, that someone's thinking, oh yeah, he got it, I'm going to have a go now too. So hopefully that helps illustrate what the environment is in terms of what the property configuration is.
So my understanding of the Double Rock Ridge, and correct me if I'm wrong here, is that that's the consent that for the building / dwelling that is able to be used just for part time of the year.
That's what the conditions say, and that's the image, the preceding image I showed you that had the approved building platform. That's that Double Rock consent. Yeah. Yeah, just with the discussion around lighting, this building's section 42A report has conditions 13, 14 and 15 that deal with lighting. The outdoor lighting is consistent with what I think Mr. Skelton was saying as well. One of the issues that is in my evidence is that we didn't, one of the conditions is that all elevations need curtains that are recessive colour. And we've suggested that that's not necessary out the eastern side of the property because there's a veranda, quite a deep veranda that would already provide sufficient attenuation of indoor light. From a practical perspective, of assistance with the conditions, but I think Mr. Skelton and Ms. McAnaway are probably better placed around the landscape effects of those lightings. But from at least in terms of what the condition framework is, that's they're sitting there in part of the 42A amended conditions. That's it. Thanks. Just to clarify those things. Yeah, thank you.
Are you able to give me an idea of what, you said the building is largely not visible from the base of the road, the lake, etc., like from further away, but I'm trying to know if any of the building is positioned in a way that you could see that from outside of the site or the access road. And the reason I'm asking is that glazing activity hasn't been mentioned at all, and quite often in sites with that higher, where there's fewer properties, the glazing reflectivity does have an effect on whether or not you can see that property. So I'm just wondering how much is visible and whether that should be something we need to look at.
How much is visible and whether it should be is probably a matter for Mr. Skelton, but from a planning perspective, I'd like to think that those conditions 13, 14 and 15, or 15 sort of lighting itself, but the use of using what's the word, sort of, I've got the exact wording in front of me and I will get it just to make sure I don't pitch myself up. Condition 13 says curtain blinds or tinted windows or similar must be placed on all windows to reduce the potential for glare from windows. Curtain and blind linings must be muted colours of low reflectivity. Then condition 14 says all internal lighting must be downlights or fitted with light shades. So that's about as much as I can offer from a planning perspective. I think Mr. Skelton would be best placed to deal with questions around recommending a certain type of glazing.
I was more just to get an understanding of what I heard, I think from Mr. Duncan, was that the aim of the property wasn't to get a view, which is quite often the case. If you're going to build it there, you want to view the lake. It's not with this property, which is my understanding. Would that be correct? That it's more about the location and.
Yeah, and I think at least from a planning perspective, I mean it's siting and that sort of shallow depression takes advantage of that and takes advantage of that sort of the natural mitigation that's offered by that enclosing landforms, dealing with soft landscape specialists. And so I think that's quite a key factor. I mean, as a general principle, that siting of the building is probably a critical element rather than trying to design your way out of it.
Yeah, because there's two parts. There isn't obviously.
On that sort of the lake side, so it's quite a deep veranda that I think so responds to that clear potential. But Steve,
If I could assist, so we have provided some mitigation planting, which is in the gully to the south, and that's mainly to screen the shed. So the shed doesn't have glazing on that side. It's potentially visible from my image locations 1, 2, and 3 from they're about 7 kilometers away. But we were able to identify potentially parts of the shed might be visible there. That's why we proposed the beach planting in that location. Landform does the work. Yes.
that visit will be super helpful. When you go and stand in the gully, you get a really good sense of how effective that is.
Looking at that RNL and the heights and the sparsity of buildings or anything reflective, it doesn't take much to stand out at that level. And as to in the daytime, it's the reflectivity of the done off any glazing, and in the night it's the light. So I think they have equal weight, and we need to be aware of that. They are mitigated. So, thanks.
I think in summary though, I think from the in terms of the conditions that are supported from the applicant's design perspective overall, those conditions get there around that, where they're having to look at glazing treatment or the specific siting again. Yeah.
I guess just your opinion on the discussion before about those conditions of enduring guardianship and land management. From a perspective, are you happy that we can actually implement them? And I'm wondering how they're actually tracked. It's one thing to grant a consent and say go and plant that, that's great, but how do you propose that that is actually controlled?
Being a land use consent, it'll run in perpetuity. But looking at the section 18, just running through this now, I mean, I think as Bridget said this as well, it wouldn't hurt at all, and you could do it in such a way that it's not too onerous at all, is for some reporting, monitoring, so that there's an annual report that the consent holder submits to the council. And that also saves probably, and that can also save on monitoring and compliance costs as well on an ongoing basis. So that probably wouldn't be hard to add in. It's just the annual reporting. Yeah.
Sure, Ms. Spalding might pick up on that when possibly. In relation to the roading, and conscious that we've had the Ben's obviously have responded in relation to the application. Is there anything further from a planning perspective that you think needs to be done from a roading perspective? Or should not be done, I should say.
No, I think what's of guidance is the, irrespective of the double rock resource consent being for a backcountry hut that has a condition that the use is limited, without engaging on the issue that the condition's not potentially helpful for the council to enforce. I think that provides at least some consistency with the sort of treatment that was required for that as a subdivision. And then when you look at what's proposed here, it's a house, so it's a change, it's a change of use from farming, low intensity farming to a residential activity, but it's just one single residential activity. And so I think when you're looking for context as to what's fair and reasonable, I think that subdivision's a starting point into the end point.
Has there been any correspondence or I didn't pick it up in relation with the other users of the essentially the right of way, the road?
Yeah, Andrew can probably talk to that around, well, obviously the directors of Double Rock have provided written approval, but Andrew's probably best placed to talk to. He talks to that landowner about maintenance of the road, of the access way itself. So,
plan, how does that?
Yeah, so we have been maintaining it for about 3 years. In conjunction with that, there's a cost share process. Cost share done. Rating it 2 times now, but it's I've repaired it a couple of times, and we generally tell each other what we're doing, and we go into it.
An informal agreement at the moment, just based neighbourly.
Yeah, there's that little users. It's not no one else to tell. It's one phone call.
The right of way easement does provide a structure to that, but the practical reality of that is the neighbours talk to one another. But if that were to break down, then the right of way standard easement terms kick in and manage how those costs get shared and how that happens in the event there's not agreement and things.
Yeah, if I ring
It's a
Grant,
backstop if necessary.
if I ring Grant, he just tells me, make sure Dave's called it. And do what you're planning. We one day want to put in cattle stops. Because Grant's in a wheelchair, so he can't actually go up there by himself. He needs us to go and open the gates for him. That'd be cool.
We're not telling you whether you need a stop or not.
That'd be cool.
Okay, so my understanding is that there's going to be rainwater captured in relation to irrigation water. Is there anything else proposed or thought of in relation to capturing irrigation water for any purpose? And
No, look, the focus has been on providing sufficient potable supply and within contained water. By assessment from waterfall and set out what the treatment was. No, Andrew's probably best to talk to you how the stormwater would be used for sort of domestic irrigation. And I also understand that there's probably sufficient capacity in their supply to actually deal with some irrigation plantings or finding out what's most practical between planting in selected areas that don't need irrigation or very little versus some areas there. But apart from that, I mean, focus from a compliance perspective is just on that potable water. Yeah, so there's not much else to talk to from my perspective, unless you want to add to
I
that.
just noted that there was that you're going to collect the water. It's just going to be tanked collection, is it? Or
Yep.
Yeah.
To waste it.
And the herpetofauna, I always get that wrong, the survey, herpetofauna, in relation to the Indigenous biodiversity, and we've already kind of traversed the predator control aspect part of it. Have you got anything further from a planning perspective, or what could or be up there?
I think the requirement for that is sort of commensurate to the level of disturbance that's occurring on the site. And because a residential activity is proposed, the activity is highly regulated and the council can rightfully request information and understand the entire effects of the proposal. But you've got to look at the context of the disturbance to the site around the access and the building area in the context of the size of the site. And while acknowledging there will be some disturbance, the actual area where there's likely to be habitat for lizards, for skinks, is in that outcrop, which isn't going to be harmed, it's going to be augmented with planting, so the habitat should be increased. So from that perspective, I don't see sufficient justification to require that sort of reporting and assessment.
Has there been any consideration in relation to any required rock blasting for either Murray or if you start digging and find you've got rock?
Yep. Already done test pits and there's sufficient soil we won't be encountering rock. Done augers in all corners of the building platform with the geotago report. And that's really can't anticipate finding any.
I guess the only other thing that I've, and it may be tie in with yourself, in relation to that cumulative effect. side argument, just something that's been popping up. So I don't know whether either of you would like to comment on that.
I'll talk to that in the AE. I don't think I talked to it in my evidence. I think what's helpful again is to look at it from the context of that diagram that I had showing the environment and the existing site configuration. So acknowledging that the site is sensitive, or the environment sensitive to development generally. Cumulative effects perspective, it's not about looking at cumulative effects in the context of what might come next. It's this proposal with what's gone before, and is there a whole bunch of proposals with minor effects that change the environment to the point that it's no longer, the next development or the proposed development, sorry, won't achieve the provisions of the plan or the intentions of the district plan. My reading of the landscape assessments is that that's not at issue. And that's because of the limited extent of visibility, not using the technical words, but paraphrasing. So the issue around cumulative effects, I don't think there is one. And I think if there was, there would have been much more than a sort of cursory-ish, high-level-ish reference to it from the other participants. I think there would have needed to be, if there was cumulative effects were engaged, there would have been a relatively detailed assessment of the precise location to either existing or consented dwellings. And that hasn't happened. And I don't think that's a deficiency in the information you've got. I just think that's because cumulative effects are not at issue. And if they were, context is that this dwelling is embedded within a 200 hectare site, which sort of used as a dry farming operation on its own. So yeah, I don't think cumulative effects are an issue.
The only point I would make to that, I think it was a good answer, is to look at what the rule framework is. And there aren't a whole lot of buildings and structures that are permitted within outstanding natural landscapes. So I think the risk that there's a proliferation of structures by way of the exercise of permitted activity rights within this landscapes like that really isn't going to happen, because the threshold for structures that don't require consent within an outstanding natural landscape is so low. So every time that someone wants to establish a structure, they basically have to get consent for that. So it will allow for a very careful analysis and consideration of the cumulative effects that might arise if this was to get consented and something else was to come along. So in that really that discretionary framework which the plan sets up for structures and things in the outstanding natural landscapes of the district, I think does allow for a mechanism to really manage that cumulative effects potential quite carefully.
The garage shed by the house already, like obviously it's quite a big, will that be built to just an IL1 standard as a non-habitable?
Sure.
Yeah.
Okay, you might do, I'm just conscious of time. We might have just that wraps up for teams education. So I'm just thinking we might have a break for some lunch. And I'm just noting it's 1:04. So do we want to, would 25 minutes be enough to come back and then be done ready to go at 1:30? Did that give you guys enough to have enough time to, you need some suggestion as to where to look across the road for something you probably all know already.
But
if that's not, we can make it half an hour, which would make it 25 too. I was just thinking.
Yeah, that's fine. Yeah, let me sit down, yeah. Oh, I don't need a big, yeah.
No, we'll just grab a
Sausage.
sandwich room somewhere, yeah.
Okay, so we'll, just give you a moment and come back at that point. And we, yes, yep, and we've got Sue, did you hear that? Sue will be back at 1:30.
Yes, thanks.
Right. So, we've just got an extra person here now. Walt, would you like to introduce yourself?
Yep, Walt Denley, the Land Development Engineering Manager here at CADC.
We'll just buy some questions that way at the end. Okay. What, I'm just in as far as order for the council team, and I'm going to start with you, Walt, just so that you can go if we need that. And then so I'll go to you, anywhere I'll come to you, if that's okay. Just in case there's anything that you need to address.
You have any questions?
Sorry?
Have you got it? Here, or you?
No,
Good.
that's fine. Okay, so in relation to the especially the roading side of things, we have heard from the applicant that they are not necessarily in favour of the seal part on the parts that are over the 12.5%. Can you please explain to us what council's position is there
Sure thing.
and why?
Yeah, so council's engineering standard is formulated on the basis of both safety and maintenance. So in terms of the surface and the mountainous terrain over 12.5%, we have a requirement for that to be sealed. Now, acknowledging the advice that they put through ahead of this hearing, you know, a gravel surface can be considered from council perspective, but it needs to be a very clear acknowledgement that the maintenance of that sits with the applicant and the users. So there needs to be a very clear agreement on that place. And just to follow through up on that, I just thought I'd just read this out, which comes from our CODC roading manager. While a gravel surface may provide some additional traction in snow and icy conditions, this advantage comes with a significantly higher maintenance cost on a right of way with gradients of 12.5% and above. On slopes of this steepness, gravel is prone to downslope migration, rutting and erosion from both vehicle movements and stormwater runoff. Maintaining a safe and consistent surface is likely to require regular grading, remetalling and ongoing attention to drainage. In terms of winter performance, gravel is not inherently free from ice-related issues. Ice will still form on an unsealed surface, and any traction benefits provided by loose aggregate can diminish as material is displaced by traffic or way. So maintaining adequate traction would therefore rely on continued maintenance and replenishment of that gravel surface. So overall, while gravel may offer some short-term winter traction benefits, it is likely to result in a substantially greater long-term maintenance requirement in a sealed surface, particularly on the grades that we are talking about for this application. So long as this proposal can have agreement with the other users of that right of way, then and that maintenance is clearly covered off, then the engineering, council engineering is comfortable with that surface remaining. That's correct.
So just so for clarification, when we're talking about everything other than gravel, the council's not asking for concrete. Yeah, chip seal or tar or asphalt. If it was
sealed,
yeah,
large chip seal.
Large chip seal
would be preference.
and In relation to, and it was mentioned by the running mate, and I just would like to point out, maybe that could be provided.
Sure.
I don't know whether you would like that as there's a hard copy there, but I'm sure we can get that sent through as an. Okay, please, Jessie, can you get that sent through to as well? Mentioned that obviously you talked about the materials going down slope. So is that would that mean that there's going to be an increased stormwater requirements with specific types of, like whether you're doing chip seal or gravel? Or what's the stormwater side of things?
Yeah, so with a sealed surface, you're forming that sealed surface, you will establish the water tables and drainage at that time, and it largely looks after itself, a little bit of clearing here and there. But with a gravel surface, there's obviously a lot of maintenance that needs to be done to ensure that a consistent surface is available and appropriate for the use of the right of way.
So, and you haven't had the benefit of hearing the other stuff, the other information that's been traversed today, but is from council's perspective, what I'm hearing is that you provided the appropriate agreement can be met between the applicant and the other road user, right of way user, that you guys are happy for a gravelled roadway.
That's correct.
Was that? No, I think that is. That's all I had in relation to that. You know, have you got anything further you'd like to add?
I guess the greater concern with the right of way upgrade is not the surfacing, it's actually the width available along the right of way in terms of providing adequate opportunities. So the standard talks to all areas, passing bays every 100 metres. If there's visible sight lines between those passing bays, and obviously the right of way winds its way up, and there is limited visibility for large stretches up that road. So widening on corners and etc. would need to be undertaken to make it safe for the intended use if granted.
That's applicable to the part that's jointly used, not.
Correct. So I'm talking to the existing right of way track, not the new extension. So yeah. The standards point to 6 metres being needed for those 6 metres width needed for those passing areas and widening areas. I think yes, in this instance.
And I think through the materials, the slope side of it is addressed in relation to how that was to look. Is there anything else slope wise that you have any concern with?
No, I don't. I think so within the realms of your decision making. So, I mean, I guess the only thing I would point out is in terms of use, Previously, the previous application along with alignment was for limited use. There was an assumption that the type of vehicle that would be accessing that right of way, predominantly a four-wheel drive vehicle, and whether or not, or how any restriction could be put on this application in terms of types of vehicles that would be accessing what is just proposed to be a private dwelling, whether it be from the occupants or their visitors.
Okay, it's all I need from this side, unless you have anything further that you need to put the clarification. We're just having a look at those conditions 25 through 29. And Ms. Royce has pointed out that these are not quite in alignment with some of the things that pointed out. So whether two of you could, pending the outcome, you could have a review to the council's requirements on that.
Absolutely.
With a note. Okay. Okay.
Any other engineering, anything else from the engineering side, please?
No, I think it's
Okay.
pretty good. Thank you.
Yes. I just thought the name, there might be some questions on the waters.
On the what,
Okay.
sorry?
The water supply, but that's okay. If that's been covered off in the engineering advice, I'm happy to leave it.
What a leading question. Okay, Paul, would you like to elaborate on any concerns that you may have with the water supply?
No, it's just in terms of the requirement for sufficient potable storage. We're relying on a water take that has in the past been restricted or even gone dry. And so just ensuring that the adequate storage on site, storage volume will be met, and that can be done engineering design if approved. And I just wanted to highlight that fact, the take from the Scrubby Gully under that Baker Regional Council consent does require a flow to be maintained in that stream. So in a drought situation, there is no chance that would not be able to be used for a period of time until such rainfall is refreshed. So just having sufficient storage. And I think the resource consent and the engineering advice covers it. I just wanted to make that clear.
Thank you. You don't need to anything further in relation to water now.
I didn't have any further before I answered it. No, I don't think so. Just
if we need to call on you, we'll get Jessie to.
Absolutely.
You're very, obviously you're very welcome to stay, but I understand that you're under pressure pump. Sorry. Thank you for
Thanks, Tim.
calling in. If we have any other further questions, we'll get. Yeah, Jessie.
Sounds good.
Thank you. Okay, so
Hello. I'll turn my camera on.
great. So when we look that way, we can see Sue this side, so you can see her here and we can see it. That's when we're not just staring at you wildly.
It's a little bit disconcerting looking at myself from the background.
Would you like to take us through your report, Sue?
Sure. I'll just give you a brief summary if that's all right. It's obviously a peer review of Mr. Skelton's assessment, and I broadly agree with Mr. Skelton on a number of matters. I think importantly the Eastern Pisa foothills landscape is a useful scale to consider the subject area at. The area, I agree that the area is characterised by openness, expansiveness, exposure, remoteness, and very sparse, limited development. And I also agree that the proposal has been carefully cited and that visibility is limited, and that the landform, the containing landform that has been talked about, provides some real containment. And I have also acknowledged, do acknowledge that the landscape management plan has some benefits. However, I think in regard to visual effects, so notwithstanding the limited visibility from most of the public viewpoints, which I agree with, I think the area that we differ is that my view is that within this ONL, the considerations aren't simply about whether the dwelling is visible. Its visual context is equally important, has to be weighed up, and in this instance, it's whether the proposal is introducing built form and domestic activity into a landscape that's valued for its naturalness and openness and undeveloped character, and it forms a prominent backdrop to the Cromwell Basin. So there was some small difference in our weighting of effects in that regard. I believe I've gone low to moderate, which is minor in RMA language. I actually agreed with Mr. Skelton in regard to the visual effects that you were discussing earlier from the unformed road. That's the closest potentially publicly accessible viewpoint. He stated they were high, and I agree. And I don't put any particular weight on that. It's one viewpoint out of many, and neither have I sort of accumulated all the viewpoints and come up with sort of an average. I think effects from that point will be high, but I accept the discussion that has gone on around the limited number of viewers, and the difference in the unformed track versus the access way, the right of way. In regards to effects on landscape, I think that's probably where perhaps our greatest difference is. I also differ in the weight that I've given to introducing this permanent residential activity and domestication into what I consider an elevated and sensitive part of the Pisa Range ONL. And in my opinion, that means effects on the landscape values and character are not as low as Mr. Skelton had suggested at the subject area scale. However, we do both agree that those effects reduce substantially once you're talking about the wider regional landscape or wider Pisa Range ONL. And I think that's the useful thing about assessing effects on landscape at a range of scales. And I appreciated that Mr. Skelton set out those scales to clearly describe the existing environment. It's really helpful. I think when you're assessing effects at the development site scale, which is literally sort of the footprint of the development that we're talking about, if you are only going to consider those effects, they would be overstated because obviously there's going to be a large change where there currently is none in a very localized area. At the opposite end of that is considering the whole ONL spatially. You can understate effects when you're considering a very small development in the context of that much bigger outstanding natural landscape. So that's where the subject area of the eastern facing Pisa slopes, I think, is a very useful one. It is a sort of coherent landscape, as Mr. Skelton said, and that's where our finding of effects differs. I don't consider effects will be high or significant, but in rating them as moderate, that is a meaningful change in my view. And I guess my concern is that there'll be a shift in character from a sort of sparsely developed and remote backdrop towards some more domestication where there currently is very little. And I think that's what my moderate effects rating effects. I could just add one thing. There's been some discussion obviously about the landscape management plan, which I do consider will have some positive, particularly positive effects on biophysical landscape values in that ONL. To my mind, they don't automatically sort of offset the effects of domestication or building in that landscape. They are to my mind, they are two different things that you're weighing up. And I have considered the enhancement of that landscape in coming to my conclusions, but I don't think they offset the effects of domestication in that landscape. They have a different positive effect.
Questions, Sarah? I asked this question earlier in relation to the fauna survey. This it wasn't brought down into the conditions. Do you have any comment or discussion in relation to that?
Sorry, I missed what survey? I missed the
Herpeto fauna? I always get that, yeah. Herpeto fauna survey for the lizards.
Not my area of expertise, I'm sorry. It's for an ecologist, I think, really, to comment.
Yeah, okay. Are we with me? Just go to that, right. So with what you've heard today, what you're saying is that you don't believe that that the mitigations that have been suggested are going to change your thoughts on that weighting in relation to the effects.
That's correct. Yeah.
What about the access track? Have you got any thoughts in relation to that? You did mention it earlier, and that you pointed out that was only one curve point.
Yes. So in terms of visual effects, from the access track, to the development. I was very interested to hear the discussion about the effects of any changes to the access track itself, particularly if the applicant had been required to seal parts of it. And from a landscape perspective, I would, it depends. I don't have a good handle on the extent of those corners and those slopes and how much that change that would require. And it seems that perhaps it's not going to be a key matter after all. But to my mind, having to seal that access track would further reduce effects. I think that would be uncharacteristic of that landscape. I'm not sure how visible they would be because I'm not sure where they are. But if they had to be sealed, whether it was chip seal or asphalt, although chip seal would have slightly less of an effect, to my mind, that would sort of compound the potential effects. So leaving it as gravel, I think, is a positive for landscape.
Okay. Thank you. That's all for us, unless you've got anything further. At the moment, you're going to stay online though, aren't you, sir?
Yeah, I am. I'll just
There's something else
shut
pops
my.
up while we're talking.
Yeah.
Yeah. Okay.
Emma Spalding, I'm the planning consultant working for Taylor Planning, in the section 42A report. We've heard the application seeks to establish a 6-bedroom dwelling, detached shed, upgraded access, servicing earthworks and landscape mitigation. Site is a large rural zoned property on the eastern slopes of the Pisa Range within an identified outstanding natural landscape. Proposal is assessed as discretionary activity, principally because it involves new buildings, access and earthworks within the ONL. The application was fully notified at the applicant's request. 3 submissions were received, 1 in support and 2 neutral. The section 42A report contains an assessment of environmental effects. I largely agree with the applicant's planner, Mr. Barr, that the key issue for this consent is the landscape effects. The applicant's landscape assessment concludes that the proposal is appropriate. However, council's peer reviewer considers that although the dwelling has been carefully sited and will have limited visibility, it would introduce permanent residential activity and domestication into an elevated and highly sensitive part of the Pisa Range ONL, would result in low to moderate visual effects and moderate adverse landscape effects, the relevant landscape scale. In terms of the objectives and policies assessment, the district plan contains a strong direction to protect the ONL values from the adverse effects of inappropriate development, but also acknowledging that outstanding natural landscapes are not landscapes from which people and communities are to necessarily be. In this case, the proposal would provide for the well-being of residents through the proposed residential use of the land, would involve ecological enhancement and landscape management benefits. However, I do not consider these benefits outweigh the moderate adverse landscape effects of the proposal and the policy direction to protect this outstanding natural landscape. I consider the scale, permanence and domestic character of the proposal. This part of the Pisa Range would result in adverse landscape effects that are not outweighed by those wellbeing considerations. Accordingly, I consider the proposal as inappropriate within this ONL. Because I've reached this conclusion, I also consider that the granting of consent would raise plan integrity and precedent concerns. For those reasons, my recommendation remains that the consent be declined. if the panel is minded to grant consent, I recommend that it be subject to the draft conditions as attached to the 42A report with the potential changes we've talked about today. And majority of effects relating to access, wildfire risk, servicing, earthworks, geotechnical, natural hazards, heritage, archaeology, and ecology are generally capable of being managed through conditions of consent. The exception to this was the potential effects related to lizard management. Later in the processing, we requested some further information after notification, which when that came back, there was some earth mounting to be put in place to provide additional mitigation for the garage. And that earth mounting was quite close to the rocky outcrop of the enclosing rim. And there was also agreement to widen the access road 4 metres wide to accommodate fire appliances. Then also the engineering team have recommended further widening of the access for passing bays to create more visibility around corners. So that just raised a concern with me that the effects of all those additional earthworks hadn't fully been considered. I'm just aware of other consents in these kind of environments where lizard management has been quite a key consideration. So my preference was that this be addressed prior to granting of consent, if consent is granted, and that panel would potentially request that to be addressed rather than address it through conditions of consent. Just because we don't have any information about that, whether there's any threatened species up there.
Is there, I guess, a level of earthworks that triggers a lizard survey?
The trigger for earthwork in an ONL is quite low, like 20 or 50. Remember the exact cubic metre, but that one's 1,000 metres. Without all this additional earthworks being recommended. I also note that the applicant's planner has raised several matters regarding the draft conditions in relation to the formation of the access lighting and the necessity for sprinklers. I still think the sprinklers are necessary based on the recommendation from FENS. We've heard from Mr. Denley that a gravel access would be acceptable, so recommend a change to the condition around that requirement. And the lighting condition, the lighting plan attached to the application, but it wasn't for this specific building as proposed. So Ms. McManaway wasn't able to rely on that in her assessment. We did request an updated lighting plan for this building, but provided, so that's why we've included some of those conditions of consent, those concerns.
Just going in relation to the sprinkler, Duncan in his evidence and expressed that he is going to have that in the dwelling. Given everything you've seen today, do you think that that condition is warranted? And also noting that it hasn't been brought down into the conditions, has it, or has it? It's misleading. The sprinklers. If it has, can you just point that out to me, please? And I guess my concern is what's the intent of the sprinklers? We've talked about are on the outside of the building, and in relation to fences, said what their requirements are. What we're talking about from an internal perspective, going out?
So it is in the conditions, it's in condition 21.
Oh, yeah, okay. Thank you. Yep.
And essentially, my perspective, if there is a wildfire, I understand the main cause of danger to buildings can often be embers making their way into the internal area of the building, whether it's through a window or subfloor area. And then that can cause internal combustion of the dwelling as well. So sprinkler would help control that. Or environmental fire appliance can get there, just noting that is the distance.
Yeah, in your opinion, would there be any situation where there was a reverse risk in relation to the sprinklers preventing a possibility of a fire escaping from within a building to outside?
I'd say that's probably beyond my area of expertise, but as I understand it, a sprinkler system wouldn't completely put out fire. It would just to allow residents to get out of the house and fire brigade to arrive.
Obviously, I'm just trying to get at, I understand we're dealing with RMA side of things. However, when we're talking about an ONL, if there was any, I guess, situation where a reverse activity could happen and potentially somebody sitting on the deck with a cigarette. I'm not suggesting that you smoke, but there's the possibility, or perhaps something happening within the home. If nobody was at home, and that could potentially, would that have the potential, in your opinion, to spread into and create the fire itself?
A house is risk of a house fire in any zone, any area. It's in a dry shrubland around it. Although I would note the landscape proposed has been planned in relation to fire hazard setbacks from the dwelling.
In relation, you did touch on the lighting. Are you, do you have anything further that you want to add in relation to what would be required in relation to lighting, bearing in mind the applicant has said that they will be following the district plan? And have taken that into consideration. Is there anything further?
I think just the condition that was recommended was that eastern facing windows should have either tinting or curtains or blinds. Still recommend that is proposed. And there is one helpful thing which might be worth looking at, which is the cross sections of the enclosing room and the dwelling. So you can just consider the height of the dwelling comparison to the landform, and that was provided as part of the section 92 information.
I should have got first because you pretty much asked what I wanted to know about. Yes, not specifically for you, perhaps this is something. The fire risk, I think Tracy was alluding to, there's both directions, isn't it? Are we putting a habitable building into an ONL landscape that we then could potentially have an effect on with a house fire? So is that the primary reason for that sprinkler system to be included in the house, or was it just the preservation of life and protection of the building? Because we're kind of getting into building code there as well. That's obviously covered the building itself. So I think the only thing that I would like to just be confident on is the curtilage area that's been in the landscape plan. Is that based on a house with a sprinkler system suppressing a fire threat? Is it for the reverse? Is it for wildfire taking the property out? I guess both are something to consider. Just whether they're negligible or not, I don't know enough to make a decision.
I think, I don't think the landscape plan and the setbacks are based on either sprinklers or non-sprinklered houses. As far as I'm aware, the Ben's advice to include a sprinkler system is mainly for life. It's time for residents to build in.
Would there be if a condition was posed elsewhere, I'm not sure what yet, I'm just thinking out loud really, like if there were an alternative method of safety from fire, I guess the section C of the building code, you know, if we can look at an alternative sectional preservation option that was equal to those sprinklers, you would consider that in that case, then they would be of equal merit. The function of the sprinklers, if we could find, if they were able to find something just had the same capability, different method, is it the preservation of life is key to that? I'm guessing is the.
Yeah, I think so. May just require some more consultation with FENS.
I think that's.
And I guess the only other thing, just in relation to the authorisation of the historical hut. I mean, obviously, you think the agreement there in relation to that. Is there anything further that you want to add in relation to that part?
So I think it's in a good location on the site where it's not visible and it's quite small scale. It's quite a light colour, so I've just recommended be painted a darker colour. And it not be used as a separate dwelling or visitor accommodation.
Okay, so I don't know whether you guys would like to take a moment and come back to us. We do have a room available for you guys to go and spend some time if you would like to do that, and how you would like to do that. I mean, I do note that we will be doing a site, as you've spoken about, we will be doing a site visit. At this stage, it's probably going to be looking at weather dependent, obviously, and your team is possibly Friday at some stage that we can work in with you guys. So just keeping that in mind, if that works.
I don't have to know.
Yeah, I'll have to know that works. Other than that, you guys, we can have a quick pause while you guys would like to reconvene if you like.
Yeah, we might just take 5 minutes and I'll just check that the little notes I've made to kind of cover off in closing, capture everything. And then probably what I'd suggest, or I'd like to suggest, is that we do that. And then again, similar to the previous one, we provide just an updated suite of conditions, perhaps by the end of the week, just to nail down any last details in terms of what we're proposing there to align with you doing your site visit, and hopefully that enables the hearing to be closed at that point.
And just bearing in mind that we've directed Mr. Denley, Ms. Spalding, in relation to those specific ones about access. So 25 to 29.
Yeah.
So there can be some work between the three of you guys to come up with something that's suitable. That would be great.
Yeah, no worries.
We'll pause there and do what Jessie will show you if you want to take.
Yeah. So just a couple of things that I wanted to address. So first, going back to the access. So obviously, Mr. Denley has advised that the council, I suppose, doesn't object to it remaining a gravel formation. And I suppose just expressed some concerns, but wanting to ensure that maintenance and things like that were dealt with. So obviously a right of way, the right of way easement already sets out the maintenance obligations of the parties that rely on that access. So I don't think there's a need for anything additional in relation to the mechanisms for maintaining the access way. I'd also point to the fact that the Double Rock property, which is the other property that benefits from the right of way, they have provided their affected party approval. So any adverse effects of this application on them are irrelevant to your considerations. And I'd also point to the fact that in the consent application for the Double Rock hut, they equally sought not to establish ceiling on the access way, on the oversteep sections. So I think when you put all of that together, there's a sort of clear and consistent message from those who are reliant on the access way that they would prefer to continue to manage the gravel formation over establishing the ceiling. Turning to the sprinklers. Now, our understanding from the conversations that Craig had with FENS and the email communication that was included with the response to the request for information is that the sprinklers are effectively about preserving the building, recognising that it is isolated from the fire station. In my view, that's not a sort of resource management effect that you need to manage. Andrew set out in his evidence why he would prefer not to install sprinklers. The preservation of life sort of issue that you raised, that is dealt with by the fire alarm system that will be required to be installed through the building code. In terms of the, I suppose, propagation of fire in the event that there was a house fire, I mean, there's been no concern raised by FENS in relation to that issue specifically. Obviously, there are going to be those setbacks and that sort of curtilage area designed to help stop fire coming in, and those would have some benefits in terms of propagating fire beyond that. And in relation to that point, I would also simply note permitted baseline that we have in a rural environment for fire and the tendency for people to use burning off or whatever for managing the farming activities. So I don't think we need to get to the point where the use on the site is presenting no risk of fires occurring at all. So it remains our view that the internal sprinkler system is not something that you need to impose by way of conditions of resource consent here. If you could provide for an either or, so a sprinkler system or the sort of standard firefighting provision, which would require additional, I think the extra 30,000 litres of standing storage for firefighting purposes. And that would then leave it open for a choice to be made by the applicant in relation to that. To Mr. Denley's point around the water supply, again, there is going to be a lot of water storage on the site. It's proposed to have the 2 storage tanks plus additional storage for the rainwater capture. So based on that, Andrew's quite satisfied that he will have access to a good supply of water to carry him through a dry period. The herpetofauna survey. So it's my understanding that the habitat that we are concerned about in that regard is effectively wrong. the rock outcrop around the building site isn't going to be disturbed. So it's our view that the habitat of concern isn't affected, and so it's not necessary for there to be additional information provided in relation to that. To Ms. Spalding's point around potential earthworks for the access and things like that, I just ask that you pay particular attention as you're working your way up the access. We're talking about, in essence, a driveway going through farmland for the most part. And so again, I don't think it likely that habitat where lizards have tended to occupy is going to be affected that would justify that additional work or conditions to manage that. And then I think if you look on the flip side of that, the proposal includes that landscape management plan, that establishment of additional vegetation, ongoing pest control. And if there is a consistent theme that you hear when you listen to ecologists, it's about the damage that pest species do to Indigenous biodiversity. So if there are gains to be made through this application, it is through the management of those pest species. And so I'd encourage that to be the focus of the consideration rather than ecological surveys for no particular advantage. I suppose that just brings me back to the landscape issue. And I think where we are effectively sitting is that the moderate, like if you were to accept Ms. Manaway's assessment, there are moderate effects in relation to landscape character. That's sort of being one aspect of landscape values. If you look at the continuum that landscape architects rely upon when assessing the effects, moderate effects sit at the low end of the minor effects. They don't get into effects that are considered significant. And so on that basis, it's my submission to you that this is not a development that gives rise to effects, or that is an inappropriate development. We haven't reached that threshold. We are proposing through the landscape management plan additional steps that will serve, as Ms. Manaway pointed out, to support and enhance other aspects of landscape value, and also other aspects of, I suppose, matters of national importance around biodiversity and things like that. So I think that's the key sort of evaluation for you to do when you're assessing whether consent should be granted or not. We have one aspect of landscape effects where we're scooching over from less than minor into minor. And then we've got a range of other landscape values which are being served and enhanced, quality of the environment being improved, Indigenous biodiversity values being enhanced on the other side of the equation. And when we put all of that together and look at it relative to the policy framework in the plan, which recognises that outstanding landscapes are working environments, that people will do things in them, that Andrew and his family will be able to provide for their well-being, I think that gets you to a conclusion where consent should be granted. I think that is it from me. Do you have any other questions? As I say, what we'd propose to do is perhaps wait for Emma and Walt to make any amendments to that access condition. And then we will also just propose some amendments based on some of the discussions we've had today around the landscape management plan and things like that, just to hopefully reinforce those and then file those by end of the week. Suits you.
And just bearing in mind that we're reducing will get a time. Just looking feel for the site visit.
Friday afternoon, being.
It's fine weather.
Yeah, weather dependent.
Yeah,
We- So
It
Jessie,
is fine, sorry, it is going to be fine.
Yeah.
Oh, it is good weather.
so do you want, are you moving for Jessie to
I
liaise?
think just liaise directly with Andrew, yeah.
Yeah.
Yeah, I
Okay.
don't need to be in the middle of that.
Anything further?
We're free to roam around a little bit on site, like there's no hazards or anything that we need to be aware of.
We can deal with it.
Like,
Get
yeah,
it.
but we're,
Have a look.
like there's, we can access everything up there when we go.
Health and safety briefing up there.
Might see a couple of goats.
Okay. Right, so the. Anything further?
No.
Sorry.
Okay, so the decision of the hearings panel was reserved. Obviously, the formal decision will be in writing. And available within the statutory period of 15 working days. In any delay, we will delay. Now it's adjourned. Thanks very much, guys.